Welcome to the 20th edition of Nani Palkhivala Memorial Tax Moot Court Competition 2025 conducted by School of Law, Shastra University, Tanjavur. Today, we have gathered here to witness the final rounds of the competition. I'm the court manager for the rounds. Before commencing the rounds, I take immense pride and honor in welcoming our panel of judges for this round. Honorable Justice T.C. Saravanan, P.H. Pandian, K.R. Sekar. Honorable Justice T.C. Saravanan is a distinguished judge of the Madras High Court, renowned for his extensive expertise in various legal domains, including intellectual property rights, excise, custom and service tax, and sales tax. We welcome you, sir. Shri P.H. Pandian. Shri P.H. Pandian is a senior advocate and formal additional advocate of Tamil Nadu. He has 30 plus years of practice in the bar with core specialization in corporate law, mergers and acquisitions, insolvency and restructuring, and tax law. We welcome you, sir. Shri K.R. Sekar is a partner at Deloitte India who with extensive experience in taxation consulting, and he has contributed to the field by representing taxation to the Government of India and authoring several books. TC12 is the appellant and TC11 is the respondent. Now the court clerk will explain the rules for this round. Thank you.
Good afternoon all. I am the court clerk for the final rounds. The round will progress for a total of 1.5 hours. Each team may submit their arguments within 45 minutes, inclusive of the 5 minutes allowed for the rebuttals. Speaker 1 of the appellant will speak for 25 minutes and Speaker 2 will speak for 15 minutes. Rebuttals will be for 5 minutes. Speaker 1 of the respondent will speak for 25 minutes and Speaker 2 will speak for 18 minutes and sub-rebuttals will be for 2 minutes. The time cards will be shown at the start when 22 minutes, 18 minutes, 12 minutes, 7 minutes, 5 minutes and 2 minutes is left, and also when the time is over. In case any of the participants want to pass a submission to the bench or a chit to the speaker, it shall be handed through the respective court managers present at the either of the side. Now, if the judges permit, the appellate side may start their argument.
Counsel seeks permission to approach the dais. Greetings to the Honorable Bench. The counsel in this matter is representing the petitioners and will be dealing with the first, second, and the fifth issue, and my co-counsel would be addressing the third and fourth issue. If your lordships are well versed with the facts and jurisdiction, the counsel would like to proceed with the arguments. Much obliged, your lordship. Lordship, in the present matter, the first issue at hand deals with the question of whether the Honorable ITAT has erred in considering the time limitation to pass the order and directions by the transfer pricing officer, the dispute resolution panel, and the assessing officer within the stipulated time period. Your lordship, the stipulated time period mentioned in the issue deals with Section 153 of the Income Tax Act. Section 153 of the Income Tax Act states the time limitation for assessment, reassessment, and recomputation. If your lordships may kindly refer to the compendium submitted by the petitioners in the present matter. Page 116, flag number 22. Petitioners, your lordship.
Number?
116, flag number 22.
Flag 20. Yes.
Your lordships are with me. Your lordship, Section 153 of the Income Tax Act provides, in the proviso highlighted, specifically states that for the assessment year 21-22, the time period available is of 9 months. In order for an assessment year to be, valid. Your lordship, further in the present matter, it was referred to the transfer pricing officer under Section 92 CA of the Income Tax Act. Therefore, Section 4 also is applicable. An extension of 1 year has been provided. Therefore, a total of 21 months was available with the assessing officer. Your Lordship, if you may kindly refer to the timeline mentioned on flag number 1, page 3.
Page.
Page 3, Your Lordship. Page 4, Your Lordship.
Yes.
Much obliged, Your Lordship. The timeline helps us to understand that a notice was issued on 13th May 2022, but the order passed by the assessing officer was on 29th of January 2024. The time limitation.
Again, the page.
Indeed, Your Lordship. Your Lordship, the notice. Your Lordship, it is mentioned on the compendium, page 4, flag number 1.
Yes, go ahead.
Much obliged, Your Lordship. Your Lordship, the list of dates helps us to understand that the notice was issued on 13th of May 2022, but the order was passed on 29th January 2024. There is a clear violation of 28 days on the part of the assessing officer to pass the final assessment order, Your Lordship. The extreme right-hand side column helps us to understand the time limitation provided under the Income Tax Act, Your Lordship. Your Lordship, further, the Council would like to state that no specific reasons were provided by the assessing officer for outrightly violating the time period provided in Section 153 of the Income Tax Act. The involvement of DRP, that is a dispute resolution panel, does not in itself gives the authority to the assessing officer to override Section 153, which is a safeguard for assessment proceedings, that is for assessment proceedings to come to a finality, Your Lordship. Lordship, if you may kindly refer to the compendium, page 6, that is the case of Shell Drilling versus Assistant Commissioner of Income Tax. Page 6, flag number 2. Your Lordship, para 28, if Your Lordships are with me. Your Lordship, it has been specifically stated by the Honorable Bombay High Court that Section 153 of the Act was prevail and above and over Section 144C of the Income Tax Act. 153 has been regarded as a mandatory provision and has to be followed by the department, Your Lordship. And in this present matter,
That the issue, the decision or the submission of the council?
Your Lordship, the submission was upheld by the court in this matter. Much obliged, Your Lordship. Your Lordship, in the present matter, the involvement of TPO gave an extension of 12 months to the department, which was also violated. And DRP in itself does not provide for any extended time period, Your Lordship. Therefore, the Council would like to submit that there has been an outright violation of the time period stipulated under the Income Tax Act. If Your Lordships are satisfied, but the Council would like to proceed.
How many days delay is there?
28 days, Your Lordship. If Your Lordship may refer to the timeline, the order was supposed to be passed on 31st of December 2023, but it was passed on 29th January 2024. As per the provision of Section 153, the 21 months time period comes to an end on 31st December 2023, Your Lordship.
Was this raised before the tribunal?
Indeed, Your Lordship.
What was the tribunal observation on this?
The tribunal did not give any consideration to this aspect and upheld the order of the assessing officer, Your Lordship.
But what was the observation of tribunal on 153 versus 144C?
Your Lordship, the moot prop is silent in those regards. It is just specifically stated that the tribunal upheld the order passed by the assessing officer. Therefore, no regard was given to the time violation by the department in this present matter, Your Lordship. If Your Lordship is satisfied with the first issue, the Council would like to proceed with the second issue. Much obliged, Your Lordship. Your Lordship, the second issue at hand deals with the pertinent question whether the Honorable ITAT has erred in considering the outer time limit provided under Section 153 of the Income Tax Act. Your Lordship, it has been specifically stated in the judgment of CIT versus Roka Bathroom that is mentioned on page 10 of the compendium, flag number 4. If Your Lordships are with me. Your Lordship, it has been specifically stated in para 27 that the provision of Section 144C and Section 153 are not mutually exclusive, but are rather mutually inclusive. The period of limitation prescribed under Section 153 is applicable when the matters are remanded back, irrespective of whether it is to the assessing officer, the transfer pricing officer, or to the DRP, that is the dispute resolution panel. The order had to be passed within the time limitation stipulated under the Income Tax Act. Your Lordship, the internal mechanism, that is section 153, 144C of the Income Tax Act, has to be altered with regards to section 153 of the Income Tax Act. It has to encompass with the time limit provided at large, because section 153 is the exclusive provision in the Income Tax Act which deals with this issue, Your Lordship.
So your submission is that 144C does not prevail over 153. 153 is subject to section 144C. Is that your submission?
In the present matter, the council is trying to submit is that there should be a harmonious interpretation of both these provisions, but section 144C should not override the external time limit provided under section 153 of the Income Tax Act, Your Lordship.
How does the 144C start? Does it start with a non-obstante clause or it is general clause?
Indeed, Your Lordship. If Your Lordship may kindly refer to section 144C of the Income Tax Act that is provided in the compendium. The council like to take a moment. It is on page 121 of the compendium, Your Lordship. Your Lordship, in the present matter, the order passed by the assessing officer comes within 144C subclause 13. It says that upon receipt of directions from the dispute resolution panel, the assessing officer has to pass the order within 1 month, notwithstanding anything contained in the contrary to section 153. Your Lordship, if you may refer to shelf drilling, the case helps us to understand that the non-obstant clause present in 144C does not override 153. This issue had been dealt by the Honorable Bombay High Court, and they have specifically stated that 153 shall be abided by because there should be a finality to the assessment proceedings, or there will be undue harassment of the taxpayers, Your Lordship, for an endless period of time.
How do you say that the assessment order that has been passed on 29/1/2024 is not barred?
20, indeed, Your Lordship.
Go to your page number.
On 29th,
Just seeing your list of date of events.
indeed, Your Lordship.
Page 4,
Indeed, Your Lordship.
you have said the direction was issued by DRP on 31/12/2023.
Indeed, Your Lordship.
It is to be 30 days. It has been passed within 30 days. How do you say it is beyond the period of limitation then?
Your Lordship, the council here is trying to say that the limitation period, that is stipulated time period referred to here, is as per section 153 of the Income Tax Act. As the council has established in their arguments, this time period has been outrightly violated by the department, Your Lordship, because the time period of 153 ends on 31st of December 2023. That is on the date the DRP issues its direction.
Just one clarification.
Indeed.
According to you, based on 153 provision, when does the time limit starts?
From the issuance of notice, Your Lordship.
153 issuance.
143 issuance of notice, Your Lordship. Because 153 exclusively states that no order of assessment passed under 143 or 144 of the Income Tax can be beyond this period that is mentioned in section 153 of the Income Tax Act, therefore making it a mandatory provision to abide by the department. If Your Lordships are satisfied, the council would also like to state that when an order passed by the department is barred by limitation,
13/5/22.
It must have.
Yeah.
It must. Read 150. No, they say it's 30 days.
30 days. No, 30 days from the end of the DRP order.
Receipt.
Where 153, her point is that the entire assessment is from the date of issuance of notice 13/5/22. To be completed by 31/12/23. That is the issue that.
How do you reckon the limitation from the date of end of the financial year or from the issuance of the notice?
financial year, financial year. Your Lordship. If Your Lordship may kindly refer to 153 of the Income Tax.
No, you do one thing, if you don't mind. Apply 153 to the dates what you are given and just help us to understand how you are violating the 153 time limit.
Indeed, Your Lordship.
Okay.
Uh,
While we understood the concept, what you're trying to say,
Indeed, Your
but
Lordship.
take us to the specific facts on how you are overcoming the
The
153.
specific dates, Your Lordship. Indeed, Your Lordship. Your Lordship, for the assessment year 21-22 in question, the time period provided is 21 months as established by the council, Your Lordship. Your Lordship, the 21 months time,
Where do you get this 21 months?
If your lordships may kindly refer to section 153 of the Income Tax Act, that is provided on page 116. If your lordships are with me, no order of assessment shall be made under section 143 or 144 at any time. In our particular scenario, the third proviso is applicable. The proviso states that in respect of any order of assessment relating to the assessment year commencing on the first day of April 2021, the provision of the subsection shall have effect as it for the words 21 months, the words 9 months have to be substituted. Therefore, since the applicable period in this is also from 1st April 2021, the time period available was 9 months. But since the matter was referred to the transfer pricing officer, an additional of 21 months is applicable, Your Lordship. From 1st April 2021, if Your Lordships may refer to the 21 months time period provided, it states that it ends on 31st of December 2023. However, the order is passed on 29th January 2024, Your Lordship. Therefore, there is a clear and outright violation on the part of the assessing officer, which is of 28 days, Your Lordship. And no specific reason has been provided as to why this violation or why the order was not passed on time, Your Lordship. The Honorable ITAT did not give due consideration to the matter. That's why the petitioners or assessees have approached the Honorable Court in this regards. Your Lordship, the Council would further like to state that when an order is beyond the time limitation, it is barred by jurisdiction. If Your Lordships may kindly refer to the case.
Before you proceed further, explain to us, is it 21 months or 9 months or 12 months?
Your Lordship, Section 153, subclause 4 provides for an addition of 12 months when a matter is referred to the transfer pricing officer. In this present matter, 3 departments are involved: assessing officer, transfer pricing officer, and DRP. Your Lordship, first the notice is issued by the assessing officer, then the matter is referred to the transfer pricing officer. When this reference is made, the time period automatically gets extended by 12 months. That is, it becomes 21 months total.
That is 9 plus 12 you're saying.
Indeed, Your Lordship. Indeed,
You're not referring to 153(1).
No,
You're
Lord.
referring to the proviso read with 4.
Indeed, Your
That's how
Lordship.
you come.
Indeed, Your Lordship. So, and that is how a total of 21 months were applicable. If Your Lordships may kindly refer to page 13, para 9 of the compendium.
Yes.
If Your Lordships are with me. Your Lordship, in this present matter, the court has specifically stated that in view of the conclusion that the assessment proceeding are barred by limitation, it is unnecessary to examine as to whether the assessing officer was duly authorized to exercise jurisdiction. In this present matter, the court has specifically stated that when the limitation period has been exceeded or has not been abided to, then the jurisdiction of the assessing officer comes to an end in this regard. In the present matter also, as the council has established that the time limitation has not been followed by the department, therefore the jurisdiction of the assessing officer had come to an end and they were not authorized to pass an order in this regard under section 143 of the Income Tax Act. If Your Lordship are satisfied with the first 2 issues, the council like to move to the 5th issue.
Yeah.
Much obliged, Your Lordships. Your Lordship, the 5th issue at hand deals with the question of whether the non-issuance of notification to give effect to the MFN benefit under the protocol.
So, first point you have established, according to you, it's time bar. Now you want to address the issue on merits.
If Your Lordships are satisfied, the
Yes.
council like to proceed.
No,
with
we
that.
would like you to explain the merits also. We are not sure whether we will be indeed accepting your view. We've heard you.
Indeed, Your
We'll
Lordship.
take call later.
Indeed, Your
Make a
Lordship.
submission on
Indeed,
merits.
Your Lordship. Whether the 5th issue at hand deals with the question of whether the non-issuance of notification to give effect to the MFN benefit contained under the protocol to the Indica Emerald DTAA takes away a vested interest already granted and is hit by the doctrine of promissory estoppel. Your Lordship, the MFN clause, that is the most favorable nation clause, is a clause present in the DTAA, which means that when two countries, that is, for instance, India enters into a double taxation avoidance agreement with another country, that is a member of the OECD model, that is a signatory or is a key partner, then in that regards, if another treaty is being entered after that, the more favorable clause will be applicable to both the DTAAs, Your Lordship. This is what the MFN clause means. Further, Your Lordship, the MFN clause under Section 90 of the Income Tax Act, the government has been given authority to issue notifications for implementation of the MFN benefit, Your Lordship, or to give effect to foreign treaties per se.
Just have a small doubt here.
Indeed, Your Lordship.
The MFN clause in your case comes as a part of protocol or comes separately as a letter to the exchange between the two countries?
Your Lordship.
Because
Indeed, Your Lordship.
protocol has got a different role. Letters exchange between two countries has a different role.
Indeed.
So how the MFN clause, the treaty, what you are mentioning is coming under that. That's what we would like to.
Your Lordship, in the present matter, in the Indica Emerald DTAA, the MFN clause is coming as a duly notified protocol, as mentioned in the annexure of the Moot proposition. That is the last page of the Moot proposition, specifically states the protocol to the Indica Emerald DTAA. The protocol, the Moot proposition, Your Lordship. No, Your Lordship, this. I. Okay.
Yes.
Indeed, Your Lordship. Last page, that is the annexure.
Yeah.
Yes.
If Your Lordships are with me. Your Lordship, the relevant extract from the protocol of the Indica Emerald DTAA that is mentioned, it is agreed that if after coming into force of this agreement, any agreement or convention between Indica and any other country provides that Indica shall exempt from tax, dividend, interest, royalty, or fees for technical services arising in Indica or limit the tax charged in Indica on such regards, then this will be applicable. If Your Lordships may come to the last line, it has been specifically stated that the competent authority of Indica shall inform the competent authority of country Emerald without delay that the conditions for the application of this paragraph have been met and issue a notification to this effect for the application of this paragraph, Your Lordship. Your Lordship, the MFN.
Before you go to that next step, if you look at it, the competent authority of India shall inform the competent authority of country Emirate. So it is not just Indian government or Indica government alone can issue. The treaty negotiation process is that the Indica government will have to inform the country of Emirate. And the country of Emirate should also agree, and then they need to issue a notification. Is that right?
Indeed, Your Lordship.
So have you checked up with the competent authority whether they're taken into the country of Emirate?
Indeed, Your Lordship. Para 13 of the same document, that is a Moot proposition. If Your Lordships are with me. It has specifically been stated that the assessee has also filed representations before the government seeking issuance of notification for extension of the benefit contained in the Indica Sapphire DTAA to the Indica Emerald DTAA in line with the protocol. Therefore, there has been due abidance by the procedure on the part of the assessee, Your Lordship. They have filed their representation and did their part, but the government did not respond to it and did not make any changes. Your Lordship, the council would further like to state that the MFN clause, as mentioned in the protocol, specifically helps us to understand that it is the duty of the government to notify the other country that such benefit has been given to another OECD member signatory, Your Lordship. But this has not been duly abided by. Your Lordship, further, the council would like to state that
After you made the representation, And since the government has not acted upon it, what steps did you take to implement the requirements, para 13? What steps have you taken?
The assessee, as established by the council, had approached the honorable government via representation, and since no response was received, they have approached the bench for writ of mandamus in this regard.
Up for a mandamus.
Indeed, Your Lordship.
So the court sitting their appellate jurisdiction have the power to direct the government to issue a notification in compliance of the treaty agreement.
And it is just not only the government of India. We have to issue the notice to the country of Emerald also, no? Because both countries have to agree, no?
Indeed, Your
So do we think that we have the powers to do that under writ of mandamus?
Your Lordship, the council will be answering your question in twofold manner. Firstly, that this matter has been filed within two jurisdictions, that is appellate jurisdiction for the order of the ITAT passed, and for writ jurisdiction, that is under Article 226 for the issuance of mandamus. Both of these have been clubbed, answering to your Lordship's question. Further answering to your Lordship's question, in this present matter, the assessees have approached the honorable bench for the issuance of a direction to the executive to look into the matter and issue a notify the other country and enter into a discussion in this regard, Your Lordship. Because if they are not duly notifying the other country, which is a breach of duty on the part of the executive, Your Lordship. And their interference under Article 226, that is with regards to mandamus, is
Will a mandamus lie for a issue like this where you want a direction issued to give a notification? Is a mandamus possible?
Indeed, Your Lordship. The term mandamus in itself means to issue a direction. Your Lordship, executive actions can be interfered into when there is due violation of duty, and promissory estoppel has also been breached in this regard. Your Lordship, the DTAA jurisprudence, that is the international law jurisprudence, is clear in this regards that domestic law, that international agreements prevail over domestic laws. Various landmark cases of Sanofi and Azadi Bachao Andolan has also stated that international agreements prevail over domestic laws. Therefore, due obedience to these international agreements are a duty of the government, Your Lordships.
Just sorry, couple of clarifications I
Indeed.
needed. While I do agree that Sanofi and Azadi Bacholan took a law that double taxation avoidance agreements prevails over the Income Tax Act subject to Section 90 subsection 2.
Indeed, Your
If Section 90 subsection 2 is not there in the Income Tax Act, DTA will not prevail over the Income Tax Act.
Indeed, Your Lordship.
Accepted?
Indeed.
Number one. Number two, have you come across any precedents in India or international taxation whether the courts have issued directions to the government of that country and other country to issue a notification? Have you come across any precedents like that?
Your Lordship, in different countries, in different countries, the application of DTAA is in different regards. That is, notification in some countries are mandatory. And after the Nestle SA judgment, the dispute whether notification is mandatory or not has been well settled in India as well. Your Lordship, the Council would like to state that in this present matter, the Council seeks extension for 2 minutes to summarize the arguments. Promissory estoppel is a very essential part of international agreements, Your Lordship. If one party acts on the basis of the promise, a univocal promise made by the other party, and the other party withdraws from it, then in those cases, promissory estoppel can be applicable in this regard. It is a doctrine of equity and is well applicable on executive actions, Your Lordship. It has time and again been applied on executive authorities to ask them to perform the due obedience and perform their duties and promises made by them, Your Lordship. In the present matter, the assessee had approached the honorable government for issuance of notice. They did not reply. The assessee had no other way rather than to approach the honorable court with a writ of mandamus. As in this regard, there is international DTAA and international regards which are under challenge, international relations, because DTAA, the jurisprudence behind it is that it is between two sovereign nations. So the beneficial provisions with regards to sovereign nations is applicable. In this particular matter, since the dividend taxation has been limited in Sapphire DTAA, so this beneficial provision should be transferred as per the MFN benefit to the Indica Emerald DTAA as well, Your Lordship.
I only point to you. You can give it in very rebuttal. there is a UN manual on negotiation of treaties. In that UN manual on negotiation of treaties, what the government should do on implementation of MFN clause on notification treaties mentioned. Just go through it if you have a time. Just help us to learn in that when you're doing a rebuttals.
Final question.
Indeed, Your Lordship.
Tax and equity and strangers. How do you invoke the jurisdiction of promissory estoppel?
Indeed, Your
Particularly in an international arena where the tax implications have a transnational impact.
Your
The
Lordship.
assessees from two different countries.
That in that regards, the doctrine becomes even more essential to be applied in the present matter, Your Lordship, because in international taxation, in domestic taxation regards, in the case of Rom versus State of Jammu and Kashmir, the court had applied the doctrine of promissory estoppel in taxation matters for exemption claims. Your Lordship, the council would like
Fundamentally, what is the jurisprudential basis on which the principles of equity, such as promissory estoppel, is incorporated into the tax laws?
Your Lordship, firstly, our constitution imbibes the equity doctrine under Article 14 of the Constitution of India. For instance, the non-discrimination clause present in the DTAA helps us to understand that should be equal treatment of both the parties. That is, the doctrine of equity is even present there, Your Lordship. Further, the council would like to state that in the present matter, the party, that is Jade, the assessee in the present matter, has acted on the basis of the representation on the basis of the MFN clause, and this has now been retrieved, which is a clear violation of the doctrine of promissory estoppel, Your Lordship. And since the MFN protocol was also duly notified, it was legitimately expected from the government to issue such notification, Your Lordship. If Your Lordships are satisfied, I would request my co-counsel to address the third and fourth issue.
Yes, one before you close, only one point for clarification. Till the MFN clause gets notified, the treaty is not a law. Till this MFN clause gets notified, the dividend what has been paid by the Indian company to the parent company is subject to tax in India. Yes or no?
Indeed, Your Lordship.
Either at 10% in the treaty rate or at.
Indeed, Your Lordship, the rate
Right.
as per applicable.
Did you file a return of income offering the dividend as taxation?
No, Your Lordship.
Why?
As per the best knowledge of the assessee, no income tax return were to be filed because no income chargeable was payable in
So
income.
dividend is not subject to tax.
Your Lordship, as per the MFN benefit, as per the best knowledge of the assessee, they had to pay the tax in emerald, Your Lordship, not in indica.
So India is not subject to tax dividend.
As they have limited their rights in the indica sapphire DTAA, in those regards, indica and emerald cannot charge DT.
So that's the reason you are asking for invocation of MFN notification.
Indeed, Your Lordship.
Okay, thank you.
Your Lordships are
Last question.
indeed.
Are you going to do the maintainability of the mandamus or your colleague is also going to do?
The council is addressing the mandamus issue at
So-
large.
How do you say Moot Finance applies to the principle of maintainability?
Indeed, Your Lordship. Your Lordship, the council has referred to the case of Moot Finance to understand where writ of mandamus can be issued. If Your Lordships may kindly refer,
Yeah, page 82.
indeed, Your Lordship. Your Lordship, in this regard, Moot Finance has only been cited so as to understand the scope of Article 226, that is the writ of mandamus. That is, it is applicable on statutory bodies. Normally, mandamus is issued to a public body or authority to compel them to perform their public duty. That is what the council was trying to establish in their earlier arguments, Your Lordship. If
But-
Your
Something to issue for you is a public duty or
It was the public duty of the executive to issue the notification as at large, not just pertinent to the assessee, but with regards to the indica emerald DTAA, Your Lordship.
have you placed any case law to say government has exercised similar direction based on a High Court mandamus being or a Supreme Court confirming? Have you placed any case law?
The council would like to state that they have stated that in various cases, executive action have been interfered to by the honorable courts. But in this regard, the council,
I think I'll be clearer. Interference is one I understood, but enforcement, directing the state to issue the notification, taking your words, an obligation of their public duty. Have you placed any case law where the courts have enforced them to issue a notification or a direction? I would say a circular or so.
And I have supplemental question to what my learned brother is asking. Normally, writ of mandamus can be an executive direction to implement certain things. Here it is a tax policy level. That means two countries should agree for reduction of a lower tax. It's a policy level. It's not a simple rate has been prescribed. I'm issuing a notification. Let's say for a minute in a GST, I issue a notification. This is not a case like that. It is a case of moving beyond an executive to a policy level. So in your research or anything, has a writ of mandamus can be done to the tax policy level?
Your Lordship, the Council would request Your Lordships to kindly refer to the judgment of ROM Industries versus State of Jammu and Kashmir, which is mentioned on page 18, flag number 6 of the compendium.
Page?
18, Your Lordship. If Your Lordships are with me. In this regard, the court has held that promissory estoppel is only applicable when appropriate notification has been issued. The protocol to the DTAA between the two countries have been duly notified. Therefore, it is the duty of the government to abide by the principle of promissory estoppel in this regard and issue the notification. Since this duty has not been abided by, it is the Honorable High Court which can issue directions to the executive.
Simple. Issuing of a notification involves two countries.
Indeed, Your Lordship.
That is at the tax policy level, not at executive level. Does this Ram judgment, what you are talking about it, does it deal with that sort of a tax policy level is my limited question.
Your Lordship, the Council here is trying to state that as per the terms of the DTAA, which is the general meaning, it is understood that the notification with regards to change in their policy in the other DTAA was to be notified to Emerald, which has not been done. And the assessee or the petitioners have approached the Honorable Court to ask the executive to issue directions to do their part, and then the entire discussions would be illuminated. If Your Lordships are satisfied, Your Lordship.
Satisfied or not, we heard your arguments. We heard you.
We hope you're satisfied that you made all your submissions.
The Council like to add another submission to. Indeed, Your Lordship. The Council would request my co-counsel to address the third and fourth issue.
May it please the honorable bench, the council appearing on behalf of the petitioner shall be addressing the remaining issues before the honorable court. Your Lordship, the pertinent issue that arises for consideration is that whether the Honorable ITAT was right in holding that the MRO services, that is the maintenance, repair and overhauling services, qualifies as technical services by the application of the Indica Emerald DTAA and the Income Tax Act. Your Lordship, the council shall be substantiating this in a threefold manner. First of all, Your Lordship, the section 9, subsection 1(7) of the Income Tax Act, explanation 2, Your Lordship, if Your Lordship may humbly kindly refer to page number 134, flag number 26, Your Lordship.
34.
134, yes. The explanation 2, Your Lordship, if Your Lordship is with me. The explanation 2 clearly says that for the purpose of this clause, Your Lordship, fees for technical services means any consideration for rendering of managerial, technical and consultancy service. Your Lordship, after a careful reading of Article 12 of the Indica Emerald DTAA, we
Don't go to Article 12. First, explain to the bench whether it is a fees for technical service under 917. Then we'll travel to the DDA. Is it fine?
Indeed.
Okay.
Your Lordship, the law and practice of income tax by Kanga and Palkhivalas, the commentary mentioned in page number 216 of the compendium, flag number 33, Your Lordship. If Your Lordship is with me, page number 216. The commentary elucidated that firstly, whether a payment shall be considered within the meaning of FTS, your lordship,
Let's go to
must be
explanation two.
indeed, your lordship.
Explanation two.
Indeed, it states that it must be strictly
Read the
considered.
explanation two fully and then we'll go to the comment.
Indeed, your lordship. The explanation to your lordship states that the services to be well
Read it.
For
within.
technical services.
Read it, read it.
Read it, read it.
Page
Indeed.
154. Explanation.
The explanation to your lordship states that for the purpose of this clause,
Read it word to word, he's asking. Please read it word to word. Just read it.
for the purpose of this clause, fees for technical services means any consideration including any lump sum consideration, your lordship, for the rendering of any managerial, technical or consultancy services, but does not include consideration for construction, assembly, mining, or like projects undertaken by the recipient shall not be taxable.
Read it. Or consideration.
When you're reading, you should read it in such a way.
Fully.
It falls into our ears and it comes as an image in our eyes.
Nice.
So read it that way so that we understand.
Indeed, your lordship.
Read it loud.
Indeed, your lordship. Just the summary of it, the explanation to your lordship only talks about managerial, technical and consultancy service, your lordship. Your lordship, after the due perusal of the terms of the contract in the present matter, your lordship, mentioned in paragraph number 4 of the moot proposition and 3 also. The NAIPL, your lordship, if your lordship is with me, the NAIPL, your lordship, has entered into a contract with the assessee for the implementation of the annual maintenance contract. The annual maintenance contract is mentioned in paragraph number 3 of the proposition. Your lordship, the annual maintenance contract, we can understand after the due perusal of the terms that the repair of items could be done both at the facility of Indica as well as the facility abroad, your lordship. Because assessee, that is the Jade Aerospace, is the original equipment manufacturer, your lordship, in the present matter, they have an already established manufacturing facility at the country Emerald. And the contract, the latter part of the latter contract has been entered into just to facilitate and just to make use of that facility. Your lordship, it is the council's argument that a standard facility, where there is a standard facility available without giving any specialized service, your lordship, that services shall not be considered within the ambit of technical services within the meaning of section 9, your lordship. If your lordship could kindly refer to page number 31, paragraph number 36, flag 10, page number 31.
We were going to case laws.
Indeed.
Before you go to case laws, explain to the bench. You are saying that there is a repair services being carried out at a different country,
Indeed.
correct?
Indeed.
And you are trying to contend the repair services are not coming as part of the 917,
Indeed, your lordship.
correct? So let's remove the case laws for a while. On facts, how do you demonstrate that definition of fees for technical is a very wide definition? You agree with that? It's a very wide definition. It says any amount paid as a consideration for rendering technical, managerial or consultancy services.
Certainly, your lordship.
Yes. How do you demonstrate that the repair services are not technical, consultancy or managerial services? Just explain to us.
Indeed.
5 minutes. Then we'll go to the case laws and everything.
For the reference of this code, the council would like to just refer to the CBDT circular, number 715, your lordship. It is not mentioned in the compendium. If the council could pass it to the.
Yeah.
The last page of it, your lordship.
Yes.
Your lordship, the circular issued by CBDT clearly states that routine maintenance shall be covered within the meaning of section 194C and not, your lordship, 194J. The routine services, your lordship, has to be
94C comes in the context of
payment.
TDS for domestic payments.
Indeed.
can a 194C be imported into section 917 and take a position the repair services or not fees for technical services?
Your Lordship, it is the council's argument that to understand the context of repair services and major repair services and mere difference between the routine repairs, Your Lordship. In the present matter, only routine repairs has been provided because we can deduce that from the
This fact has been confirmed by the tribunal. It is a regular routine services.
No, Your Lordship,
Was it a fact confirmed by the tax tribunal? Because tribunal is last of the fact finding authority. Was it confirmed by the tax tribunal?
the tribunal has not considered with this.
It's not confirmed whether this is a regular or exceptional one.
Your Lordship, it is not mentioned in the proposition,
Okay.
but the
Okay, go ahead. Fair point. Go ahead with your argument. Sorry.
Your Lordship, it is the council's argument that clarification number 23 and 24 of the moot proposition states that the services does not make any major change, to the composition of UAVs, Your Lordship. Further, Your Lordship, NAIPL delivers similar services to other entities as well. Therefore, Your Lordship, we can deduce that these services are only in the mere nature of normal repair, Your Lordship, because the contract, as per the due perusal of the contract,
You have a car.
Indeed, Your Lordship.
Suppose your car goes for a repair. You go and give it to your mechanic. You ask the mechanic, what is the problem in the car? Yes? The mechanic says, this is the problem, this is the problem, this is the problem. And then you tell him, you repair it. Now, what is the consultancy? What is the repair in this too? Will you not apply the same logic here also?
The council would like to differ with the bench argument because Your Lordship, after the due perusal of the terms of the contract, the terms of the contract states that it is only for the providence of a standard facility, that is the OEM, original equipment manufacturing facility. And there is no specialized services, no specialized personnel is required for this matter. Your Lordship, further, it has been stated that no major change in composition has been made when the repair were done. Therefore, Your Lordship, it is the council's argument that while special skills may be used while making the composition of the UAVs, these special skills are not required when the routine repair services are done in the present matter, which is the case, Your Lordship. Your Lordship, it is further the council's.
So converse of your argument is special skills means it's a specialized services. And then therefore it becomes a fees for technical services.
Indeed, Your Lordship, multiple cases. Your Lordship, the High Court in this regard has stated that specialized services, if there is any, then that services shall be considered within the meaning of FTS. But if there is no specialized services and mere standard facility is available to the payer, then that facility shall not be considered within the meaning of FTS, Your Lordship. Further, Your Lordship, it is the council's argument that in the present matter, the OEM facility has been provided with just for the logistical convenience, Your Lordship. Setting up a repair facility at the country Indica, Your Lordship, would have been, first of all, unreasonable because, Your Lordship, the repair services are carried out just for the annual maintenance contract that has to be renewed annually. Your Lordship, setting up a facility at Indica just for a year, for a contract that has to be renewed every year, Your Lordship, that would be unreasonable and not a very cost-efficient decision, Your Lordship. Therefore, the contract has been entered into just for the use of the manufacturing facility at the country Emerald, Your Lordship.
Say that it's not a technical service which has been provided by you.
If Your Lordship could repeat the question.
How do you say it's not a technical service which has been provided for which the payment has been received?
Certainly, Your Lordship. Clarification number 23 of the moot proposition, Your Lordship. Clarification number. Your Lordship, it is the council's argument that as per the OECD report on e-commerce, it was to understand the meaning of technical service, Your Lordship, it was elucidated that in respect of special skills, Your Lordship, the special skills, it is better to understand at what point that special skill was used.
My brother asked,
Indeed.
how do you say repair service is not a technical center 917? We're going to OECD committee on e-commerce. OECD committee on e-commerce is not relevant for 917. OECD committee for e-commerce is relevant if you are taking a position under the treaty law. Now today, at this point, we are arguing only on 917, correct?
So,
Focus on 917 rather than OECD committee on e-commerce is my submission to you.
indeed, Your Lordship.
Okay.
The clarification number 23 of the Moot proposition, Your Lordship, states that the repair services does not make any major change to the composition of the UAVs. That means that the repair services, Your Lordship, were not major in nature, that were mere routine services. And therefore, the use of the standard facility, Your Lordship, is a mere logistical convenience, rather should not be considered within any specialized skill, and therefore shall not be considered within the meaning of FTS under section 9.
So therefore, according to you, it's not a service at all,
Indeed,
not a technical service,
Not
it's
a
a service.
indeed, Your Lordship.
Okay.
Your Lordship, as the source rule in the present matter, it is the council's submission that the source rule is accepted and applied in the field of taxation, and with regards to FTS, it is also applied, Your Lordship, but shall only be applied if the FTS, if the services are considered within the meaning of FTS, Your Lordship. In the present matter, the services were rendered at the country Emerald, has no connection with the country Indica. Your Lordship, these services are not well within the meaning of FTS, and therefore, indeed.
That's the reason I asked you to repeatedly read the 917 thrice. 917, the last limb says, does not include any consideration for construction, project, assembly, or other like project. In a repair, is it only a service or will it come under the last limb also? That's the reason I provoked you to think on that lines.
Your Lordship, if we refer to the Indeed, Your Lordship. If we refer to the section, the explanation, Your Lordship, it states that it excludes certain services within the meaning of FTS. Your Lordship, it is the council's argument that there is no major repairs, major changes in the composition, and therefore shall not be considered within the meaning of FTS, shall not be considered within the it is the council's next limb that the source rule is accepted and applied within the meaning of FTS. But in the present matter, the source rule shall not.
Yes.
The council would take only 2 minutes to. The other technical services, Your Lordship, are with respect to software and engineering support and design and documentation, Your Lordship. With this regard, Your Lordship, the council would like to refer to this judgment of Springer nature, Your Lordship, mentioned in page number 46, Your Lordship, flag number 16. If Your Lordship is with me. Your Lordship, the Delhi High Court's judgment, paragraph number 20, states that technical services are generally connected with applied and industrial science or craftsmanship involving special skill or knowledge, excluding fields such as art and human sciences. Your Lordship, in the present matter, the clarification clearly states that software and engineering support is divided into two things. First of all, configuration and maintenance of software, and secondly, employee training. Your Lordship, configuration and maintenance of software is mere IT support, and support services does not comes within the meaning of FTS, Your Lordship. Further, design and documentation with this regard is included in the field of art, Your Lordship, and is with respect to the UAVs, unmanned aerial vehicles, and therefore it is the council's submission that it also shall not be considered within the meaning of FTS.
Earlier you brought 194C for repair is not a fees for technical services. Yes?
Indeed.
If the support services are doing under domestic law, will 194C will apply or 194J will apply IT services?
Your Lordship, 194J is with respect to.
Itself 194J applies. Then IT services will come under 917.
So it is the council submission that 194J is with respect to fees for technical services that will not apply in the present matter. Indeed, Your Lordship. Your Lordship, 194, if we look to the terms of if we go through the 194J, Your Lordship, it also talks about fees for technical services, where technical services should include, as per the judgments, the three managerial, consultancy, and technical nature, Your Lordship. It is the council's argument that in this present matter, the mere support services are being provided, and that those support services does not comes within the meaning of technical services only, and therefore shall not be considered within the meaning of 194J and Section 9, Your Lordship.
One question,
If-
suppose the appellant was an Indian company. It had provided service with subsidiary. Payments were made by the subsidiary to the appellant from India. For those payments, was the Indian company required to deduct tax?
If Your Lordship could,
The 194C.
indeed, Your Lordship.
This brother's point is simple. Instead of a foreign payment,
Hmm.
if it had been a domestic payment, you talked about IT services,
Yeah.
software engineering and maintenance. That's what the crux, na? This payment for software engineering and maintenance, under which section you would have deducted tax? First of all, his TDS would be applicable. If it is applied under which section you would have deducted tax? That's all.
Indeed, Your Lordship. The council is, the bench is referring to the bench is referring to the 194C of the, in the present matter. Your Lordship, 198, if we consider the matter with respect to any IPL, it would still not come within the meaning of 194J, but 194C, Your Lordship. If Your Lordship is satisfied, the council would like to proceed to the prayer in the present matter.
Not satisfied or not, we heard you completely.
Indeed. Your Lordship, wherefore, in the light of facts raised, arguments advanced, and the authorities cited, the petitioner most respectfully submits, asks the court to admit the present appeal, Your Lordship. Secondly, set aside the Honorable ITAT's order and the order of the assessing officer, and then issue the writ of mandamus in the present matter under Section 90 of the Income Tax Act, Your Lordship. And pass any such order direction that the court may deem fit in the light of justice, equity, and good conscience. It was an honor arguing before this court, Your Lordship.
Good morning. The council seeks permission to refer to the bench as your lordships collectively and your lordship individually. Much obliged.
Where's the red book?
Yes,
This is your submission? Respondent submission, this red color one?
yes, your lordship.
Okay.
I'm counsel 1, representing the respondent, the Commissioner of Income Tax, South Indica, in the matter of Jade Aerospace Industries Limited versus Commissioner of Income Tax Appeals, South Indica, and the Union of Indica. Would your lordships prefer a summary of the facts of the case at hand?
You can skip that.
Straight away go to
Much obliged, your lordship. As counsel 1, I will be addressing issue 1, which is that the final assessment order passed by the assessing officer in this present tax case appeal is not barred by limitation by operation of Section 144C of the Income Tax Act. I will also be dealing with issue 2, which is that the consideration received for the services provided by the assessee in this present case, received by the assessee in this present case by NAIPL, the subsidiary company, would be taxable as fees for technical services under the Income Tax Act as well as the Double Taxation Avoidance Agreement. The counsel for the respondent submits that the final assessment order passed by the assessing officer is not barred by limitation. To establish this, although the learned counsel of the appellants have already taken the bench through the scheme of the provisions, the counsel will also finds it pertinent to take the bench through the scheme of the provisions of the Act. the time given to the assessing officer under Section 153 of the Act with respect to an order relating to an assessment year commencing on the first day of April 2021 is 9 months. This is given in the third proviso to 153 subsection 1. By application of 153 subsection 4, whenever a reference is made to the transfer pricing officer under Section 92CA of the Income Tax Act, this 9-month period is given an addition of 12 months, making it 21 months. Orders ought to be passed by the TPO anytime before 2 months prior to the expiry of the limitation date given in Section 153. This is given in 92CA, subsection 3A. In this case, the TPO passed its order on 30th April 2023, with 8 more months left for the date of limitation under Section 153 to expire. Here, the Council would like to note that the TPO has not even relinquished the entirety of the time given to it under the Act. Based on the order passed by the TPO, the AO forwarded a draft of the proposed order to the dispute resolution panel, to the assessee. So on 1st November 2023, with 2 more months left for the limitation period under Section 153 to expire. The assessee chose to exercise its option under Section 144C, subsection 2, subsection B of the Act and filed objections before the dispute resolution panel on 30th November 2023. At this point, 29 days have passed since the draft assessment order was passed, and therefore the SC was well within its bound to object before the DRP. Subsequent to this, the DRP passed the final order on 31st December 2023. The DRP still had 8 months left to complete its findings as per 144C, subsection 12 of the Income Tax Act. Based on this order, the assessment officer passed its final assessment order on 29 Jan 2024. Your Lordships, the Council will be arguing that the assessment order passed by the AO in this case is not barred by limitation on 2 folds. Firstly, on the basis of principles of statutory interpretation, and secondly, in differentiating the case of this tax case appeal with the judgment of the division bench of the Madras High Court in CIT versus Roka Bathroom Products. Here, the Counsel for the Respondent would also like to note that the case quoted by the Learned Counsel for the Appellants, which is the Bombay High Court's case, judgment in the shelf drilling Ron Tapmayer case, has been stayed by the Supreme Court by an order dated 22 November 2023. The order is with the respondent here.
Before you go to stay of the Bombay High Court and all this judicial precedents, on the facts of the case, which the learned appellant counsel has given the dates, can you tell us through the court how it is not violating 153 and 144C? Leave the case laws aside for a while. The court will take through the case laws. But on the facts, how do you say it is within the provisions of 153? Can you explain?
Your Lordship, the Council submits that the time limit under Section 153 will exclude the time limit prescribed under Section 144C due to the operation of the non-obstante clause that is provided in Section 144C.
So the first principle is 153 is independent of or 144C is independent of 153. Your first principle is that 144C is not subject to 153. Is that your argument?
Yes, Your Lordships. When a draft assessment order is passed to the DRP to give its findings, then 144C subsection 13 will come into operation, which says that notwithstanding anything contained in Section 153 of the Act,
That is
the
144C 13. Is it part of this submission?
If Your Lordships could go to page 45 of the Respondent's Compendium. 46, sorry. 46 of the Respondent's Compendium.
Got it.
Subsection 13 says, upon receipt of the directions issued under subsection 5, the assessing officer shall, in conformity with the directions, complete, notwithstanding anything to the contrary contained in Section 153 or Section 153B, the assessment without providing any further opportunity of being heard to the assessee within 1 month from the end of the month in which such direction is received. Your Lordships, in this case, the DRP passed the final order on 31st December 2023, and subsequently on 29th January 2024, the assessment officer has passed its final assessment order, which falls within the limitation period given under 144C subsection 13. In Commissioner of Income Tax versus San Meena SCI, the High Court of Madras observed that section 144C is a self-contained code, Your Lordship, providing authority to the DRP to enhance assessment beyond variations proposed in the draft order after providing the assessee with sufficient opportunity to represent its evidence before the DRP. The AO cannot introduce any new additions, disallowances, or variations that were not included in the draft order directed by the DRP. So the role of the AO comes to an end when the draft assessment order is passed to the DRP. And from there, 144C would operate as a self-contained code, which means that the timelines and the principles of natural justice which are enshrined in 144C would kick into force, and that would be applicable for the passing of the final assessment order as well. Your Lordships, the Council further submits that section 144C was inserted.
1 minute.
Yes, Your Lordship.
153(1).
Yes, Your Lordship.
Your 144C order is passed under 143(2).
If the Lordship could.
Draft assessment order, once it gets passed,
Yes, Your Lordship.
the final order is 143(2) order read with 144C. Correct? Now, 153(1) starts that no order of assessment shall be made under section 150, 143 or 144 at any time after the expiry of 21 months from the end of the assessment year. Then this 21 months has got further moderated by various provisos. That means 153 is a supreme section for time limit. 144C, though it is an independent provision with regard to the AO and the DRP order, but can 144C override the supreme section of 153?
Your Lordships, 153 subsection 1 says no order of assessment shall be made under section 143 or section 144. Here, the Counsel for the Respondent is concerned with 144C. There is no mention of section 144C in section 153. However, Your Lordship, in this particular section, it is given that there's an extension if the matter is referred to the transfer pricing officer. And under 92CA, the transfer pricing officer is required to finish his give his directions 2 months prior to the assessment limitation date given in 153. Therefore, both these sections are interlinked. However, in 144C, no mention of 153 is made, except to say that notwithstanding anything contained in 153, the limitation period under 144C would prevail. Therefore, the non-obstante clause has to be read in such a manner. If the Council can move on to the next submission. The Council further submits that section 144C was inserted by the Finance Number 2 Act of 2009, well after sections 153 and 92CA were introduced. The time limits provided in subsections 4 and 13 of 144C are to be enforced, notwithstanding anything to the contrary in section 153, as already pointed out by the Council. A non-obstante clause must be read while keeping in mind the intent of the legislature. In enacting this provision, the legislature was well aware of the existence of 153 and 92CA and still chose to insert section 144C. Therefore, the effect of such an insertion should be that the non-obstante clause in subsections 4 and 13 of section 144C is that the hitherto applicable time limit under section 153 came to be expressly excluded for the purposes of the completion of the final assessment order. If your Lordships are satisfied by the arguments if your Lordships have no further questions on the principles of interpretation that the Council has relied upon to argue that the non-obstante clause would overrule the limitation period given under section 153, the Council would like to just quickly highlight the difference between the division judge bench judgment of CIT versus Roka bathroom products by the Madras High Court versus the facts of this particular case.
Page number.
Your Lordships, in that particular case, in para
Where is
6,
it? Page number.
If you could just
Copy of the
It's not here, right?
the division judge bench judgment, the entire judgment is not reproduced in the.
But have you mentioned it somewhere?
Yes, Your Lordship.
It's in page 8 or page 9.
Your Lordship, the particular judgment has not been referred to by the respondents because the facts of that case are different to the ones. Your Lordship, the reason the respondent is bringing up this particular case is owing to the fact that the assessee has relied upon this particular case. So it is in response to the arguments of the counsel of the assessee in using this judgment as a precedent to hold that 144C would not override 153. That the counsel for the respondents is trying to differentiate the facts of that case with the case at hand.
The decision of the division bench of the Brass High Court in Roka
Yes.
is before us, also in another case. An appeal has been filed against that decision.
Yes,
It's
Your
pending
Lordship.
before Supreme Court.
Yes, Your Lordship.
That's a division bench, and we are sitting here as Supreme Court judges. We have three of us here. So we would like to understand the provision as it is. And then I would like you to explain how the decision applies in your favor or against.
Your Lordship, if the council may just seek a clarification in the proposition is provided that the appeal lies to the full bench of the High Court of South Indica. So in this case, the appeal does not lie to the Supreme Court.
Even if you take it that way,
Yes, Your Lordship.
the decision of the Brass High Court is that two judges.
Yes, Your Lordship. Yes, Your Lordship. Agreed.
Right now, we are sitting as three judges.
Yes, Your Lordship.
We would like you to still explain the provision and then explain the case, how it is applicable to you. Or you want to say that the decision is not applicable? to you? How do
Which
you want-
provision is the council supposed to highlight?
No, the entire judgment of what you are trying to say, Rota.
Yes, Your Lordship.
I was talking about the
Limitation, how the judgment is relevant to you. Whether the judgment applies to you or not applies to you. If it applies to you, whether in your favor or against, we would request you to explain to us and help us to understand
Yes,
is
Your
what we are
Lordship.
saying.
The council is.
That's what my brother is saying.
Council will be proceeding to do exactly that.
Yeah.
In para 6 of that particular judgment, I apologize for not including this judgment in the compendium. However, the para 6 of this particular judgment states that the ITAT remanded the matter back to the AO after setting aside orders of the AO by asking the AO to refer the same to the DRP for fresh examination. Some 4 years passed after this order was passed by the tribunal, and when the assessee in this particular case claimed for a tax refund, the DRP sent notices to the petitioner asking him to come for hearings. Your Lordships, the facts of that case are clearly different from the facts of this case because herein it was not a order of fresh assessment that was passed by the ITAT. This is a case where a draft assessment order was passed as per the timelines given under 153, and further the DRP has also completed its work within the mandate.
Referring to a decision which is not relevant to the case.
Your Lordship, because the judgment was quoted by the assessee in this particular matter, saying that the ratio of this judgment would apply to the facts of this case.
We don't remember them citing that decision.
We remember of shell drilling and other judgment, not this judgment we don't remember.
Judgment in shelf-
Unless we missed to hear that.
Your Lordships, this judgment in shelf drilling, which
No, would you mind if you get, oh, it is there?
It kept page number 9.
9.
Fact has been kept, is it? Page number 9 of the Appellant.
Your Lordships, even if this was not argued by the counsel for the assessee, the assessee quoted the case of the Bombay High Court in shelf drilling on tap.
I'll just read out what they quoted.
Yes, Your Lordship.
They not said that facts of this case is relevant here.
Yes, Your Lordship.
They just laid upon page 20, para 27A
Yes, Your
of the
Lordship.
ruling on the interpretation of 144C and 153.
Yes, Your Lordship.
They never, that's my recollection, that they never said that entire facts are in pari material and it applies. They just read out the paragraph of 144C and 153. To that extent, it has got a limited application.
Understood.
The court is not unduly concerned whether that particular judgment is on remanding back or anything else. This is on the principles of 144C and 153. Do you agree?
Yes, Your Lordship. The council would like to state that as rightly pointed out by the bench, that was a division judge bench judgment. And the concept of stare decisis does not apply amongst high courts. If it was an order of the Supreme Court, the High Court will be bound to follow the ratio of that particular case. However, in this matter, the full bench is free to decide on the facts of this current tax case appeal instead of relying on the judgment in the division bench, which is what the council is would like to point out, that the facts are different, and therefore the bench is free to decide on the merits of this particular case, and it would not be since the principle of stare decisis does not apply here, the bench is free to decide in the favor of the respondent, although such a judgment exists.
So your entire argument is twofold. Number one, 144C is independent of 153.
Yes, Your Lordship.
144C cannot control 153.
Yes, Your Lordship.
144C has got a non-obstante provision, 144C subsection 4.
Yes, Your Lordship.
That non-obstante provision of 144C overrides the provisions of 153 with regard to the time
Yes,
limit.
Your Lordship.
And the shell drilling judgment as well as the Madras High Court judgment is not applicable here
Yes, Your Lordship.
because of the fact that it does not lay down a proposition that 144C is independent of 153. Is that our understanding is
Yes,
correct?
Your Lordship.
Okay.
If Your Lordship had no further questions on the issue of limitation, the counsel for the respondent would like to just summarize the limitation issue before moving on to the issue for the fees for technical services. In light of the arguments made on the principles of statutory interpretation, and further based on the different sets of facts in the Roka judgment and the present case, the counsel for the respondent submits that this issue should be decided in the favor of the revenue. Proceeding to the next issue, which is that the consideration received for the services provided by the assessee to NAIPL is liable to be taxed by application of the IT Act as well as the Indica Emerald DTA. This will be argued in a threefold manner. Firstly, that the services fall within the expression of technical service. Secondly, that they're taxable under the IT Act. And thirdly, that they're also taxable under the Double Taxation Avoidance Agreement. Your Lordships, the term fees for technical service has been defined under Article 12, Sub-Article 4 of the Indica Emerald DTA as any payment for the provision of services of managerial, technical, or consultancy nature by a resident of a contracting state in the other contracting state. The definition ends here.
Don't go back DTA. First, let's examine 117
Yes, Your Lordship.
and then go to DT.
Understood. It's defined under the explanation 2 to section 9, subsection 1, subsection 7 of the Income Tax Act as services of managerial, technical, or consultancy in nature. This is given in page 39 of the respondent's compendium. The relevant portion has been highlighted in the compendium as well. Explanation 2 says, for the purposes of this clause, fees for technical services means any consideration, including any lump sum consideration, for the rendering of any managerial, technical, or consultancy services, including the provision of services of technical or other personnel, but does not include consideration for any construction, assembly, mining, or like project undertaken by the recipient, or consideration which would be income of the recipient chargeable under the head salaries. So this is the definition given under the Income Tax Act. Firstly, the council submits that the services rendered by the assessee to NAIPL will fall within the expression technical service. The first category of services are maintenance, repair, and overhaul services with respect to unmanned aerial vehicles. For this, the assessee would like to place reliance on a 2015 judgment of the Delhi High Court in DIT versus Lufthansa Cargo India 2015. But the court observed that unlike normal machinery repair, aircraft maintenance and maintenance repairs cannot be compared with contractual repairs such as cleaning, etc. Component overhaul and maintenance, especially when it comes to unmanned aerial vehicles, by their very nature cannot be undertaken by just about any entity. For this very reason, The same has been sent to the original equipment manufacturer in country Emirate, which is the assessee in this present case. Your Lordship, if this repair service could be undertaken by just about any regular standard entity, the same could have been done in country Indica itself. There was no reason for it to be imported to the original equipment manufacturer jail in this present case, and the services be rendered to it there. UAVs are sophisticated technological systems, and as such, they require high levels of technical knowledge in order for technical services to be carried out. This shows that the level of technical expertise required is specific, and that MRO services are to be rendered to these UAVs in designated centers.
So, position is that
Yes, Your Lordship.
the equipment is a specialized equipment.
The UAVs are special.
Specialized equipment.
Yes, Your Lordship.
Specialized equipment services cannot be rendered by any normal person,
Yes, Your Lordship.
and therefore it falls within the category of fees for technical
Yes, Your
services.
Lordship. Under the expression of technical services.
Lufthansa judgment was rendered in the context of Article 8, no?
Article?
8 of India Treaty, no?
Yes, Your Lordship.
You are not talking about Article 8 in your proposition or in your submission or in your facts.
Yes, Your Lordship.
It's a simple repair services. Whether repair is for a simple equipment or a bigger equipment, that's a fact of the matter. So your proposition is that since it's a specialized equipment, needs a specialized services, therefore it comes under 917.
Yes, Your Lordship.
Suppose instead of the special equipment is not, it's a special equipment, assuming it's not done in outside India, it is done within India. What would be the position for you? 194C or 194J?
Your Lordship, the counsel for the respondent is not concerned with tax deduction at source because it's the same.
A fair point, but if it had been done under India, let's say the foreign company is under Indian and you are making a payment, under what section they need to deduct taxes? So under 194C or 194J?
194J, Your Lordship. However, the counsel for the respondent would request my researcher to look into this while I continue with my submission.
The reason I'm asking is that if you go to the Bangalore Tribunal judgment on DBS India Limited, the question fees for technical services was brought in. There's an MRI equipment. MRI equipment is specialized equipment. None of us can operate the MRI equipment. If you go to MRI equipment and takes the services, it's not a fees for technical services. And similarly, in Bharati Airtel Limited, the judgment was said that it may be telecommunication equipment. In Bharati Airtel, the issue was 194C was 194J was discussed. It's a specialized telecom equipment. Merely doing a specialized telecom equipment services, it does not take the character of 194J. So I just wanted you to think about it, take time, think about it and come back.
Think further. You have a car. Nowadays, you have only the branded cars. The services are through the branded showrooms. So if you have bought a Maruti car, it goes to the Maruti authorized dealer for a service. Or for the lift, for instance, you can take the assistance of a company which has installed the lift because they are dependent on the software. Lift installed by, let's say, Snyder will not be serviced by another company, let's say Kone, or vice versa. So when this AMC is given to, is it a technical service or it's just a service?
Your Lordship, firstly, to answer the question of whether the Bharti Cellular Limited judgment would apply here, the counsel for the respondent believes that the question that the Supreme Court had considered was whether in place of no human intervention in carrying out these services, where all of these services were produced through machinery only, would fees for technical services apply? There, the court found that the application of specialized human knowledge is required in order for a service to qualify as a technical service. Here, in the clarifications, point 22 of the clarifications mentions that all repair services were rendered through human intervention. So this was not a case where all of it was done by machines. Therefore, there's clear differentiation between the facts of the Bharti Airtel case versus the facts of this case, where human intervention was necessary to carry out technical services. Would Your Lordship please kindly repeat the question that was asked?
Is there a difference between an ordinary AMC
and a service like this? Because mostly the original equipment manufacturers, as in this case of a UAV, they don't share the know-how to others. So therefore, the equipment, if it requires a service, it goes to the company which manufactures. So is it a technical service or it's just an ordinary service?
Your Lordships, there could also have been ordinary services carried out by jail. However, in this particular case, the ITAT, on the basis of the facts of the case, has proceeded that the services that were involved were not routine repair services, but that they were sophisticated technical services. So the facts have already, on the basis of facts of the case, the ITAT has already decided that the services rendered were technical services which required sophisticated knowledge of the machinery involved. Therefore, this could not be compared with regular cleaning services that are undertaken to cars, which you give to designated service centers. And also the assessee believes that such vehicles can also be repaired through other centers, but however, customers prefer to give it to designated centers. In this case, the reason it was sent to another country for repair is owing to the fact that it requires extremely sophisticated technical knowledge, and the same has been confirmed by the findings of the ITAT.
What is the method by which an assessing officer would come to a conclusion that actually it involved a technical service for the purpose of Section 9?
If it was a routine maintenance service that can be undertaken by just about any standard facility, then it would not be technical service because it would not require highly specialized knowledge in that particular area. According to the Council for the Respondents, that is how maintenance repairs are usually categorized as not being technical services.
Yes.
However, in the judgment of the Delhi High Court, although it was dealing with aircrafts and although it was dealing with the DTA, the Council for the Respondent would like to submit that unless it can be taxed under the Income Tax Act, it cannot be taxed independently under the DTA. It would have first had to qualify taxability under the Income Tax Act, Section 9. And
According to any services, first is F is for technical services. Exception if can be given only if it is a regular routine.
yes, Your Lordship.
No exception should be given to non-regular, non-routine. And Income Tax Act 917 never brought that sort of a distinction.
Agreed, Your Lordship.
So where did you get that distinction?
The definition for the term fees for technical services is given in the Income Tax Act as managerial, technical, or consultancy in nature. It
So
does not
it's-
expand on.
So let's take managerial, technical or consultancy. Number one, repair services can never be a managerial,
Yes, Your Lordship.
right?
Yes, Your Lordship.
Repair services can never be a consultancy services.
Yes, Your Lordship.
It can be a technical
Yes,
services.
Your Lordship.
Technical services, let's say repairing of this bottle. Let's say this bottle is a highly complicated, lot of technology is involved in this bottle. Repairing of this bottle, will it be technical service? Because I'm not paying for service. There's a fundamental difference. I am not paying for service. I am paying for repairing of this bottle and getting me back the bottle.
Yes, Your Lordship.
Correct?
Yes, Your Lordship.
So will it be a technical service repairing of this bottle?
If the bottle involved specialized or
Okay.
technical
So,
knowledge.
so your point is running back, specialized skill
Yes,
means
Your
technical
Lordship.
service.
The council understands that the definition, it's not been expanded in the IT Act. However, courts have generally proceeded the dictionary interpretation of the order.
Got it. I just want to get a clarity there.
Much obliged, Your Lordship. If the council for the respondent could just request an extension of time by 2 more minutes to proceeding with the second category of services relating to software and engineering support, design and documentation services. The definition of consultancy services are that if they're technical in nature, they are to be bought within the expression consultancy services. This is owing to the interpretation taken by courts in general that because consultancy, technical services, the term technical is sandwiched between consultancy and managerial, the interpretation of technical would also be applied to consultancy services. Therefore, regular consultancy services would not be considered within this ambit. However, consultancy services which require sophisticated knowledge would be considered to be consultancy services. In SkyCell Communication Limited versus DCIT, the Madras High Court opined that the expression of consultancy involves giving an advice or an opinion or counseling or advisory services by a specialist or a technician. An element of expertise or specialized knowledge and education on part of the advisor is essential. in order to constitute consultancy service. Given the niche field of the software engineering when it comes to UAVs, and as an applied science, the dispensary of its intellectual output can very well be deemed a consultancy service. The same can be said for design and documentation, which can only be provisioned from a clear understanding of the technologies of the UAVs involved, and are very specifically customized to each unmanned aerial vehicle. Therefore, the second category of services should also be considered technical services as per the Income Tax Act. Proceeding forward, we argue that under the expression technical services, the consideration received for the same is taxable under the head fees for technical services.
Just only one clarification. How do they get this software design and is it in the form of a book manual or a floppy or tape drive? How do they get it?
The facts mention that these services are performed remotely. They do not mention anything about the form in which such services take. The facts are silent on this regard.
Okay.
Your Lordships, the assessee will first, if the council could have an extension of 2 more minutes just to complete that the services will be taxable even though it was not performed in country indica.
We can skip that. Question is, the assessee has approached the department for a direction to issuance of a notification for extension of the benefit of the DTA.
Yes, Your Lordship.
The government has not acted upon it.
Your Lordship, the facts do not say that the government has not acted upon it. The facts are silent on what the government has done so far. The assessee has given representations to the government for asking the government to pass a notification in this regard and not to take consultations with other countries in order to pass this notification. And
It
that
not be mandatory on the part of the government to apply their mind and say that this is not feasible, not acceptable for whatever reason. Can the government keep quiet and then say, no, we will tax you?
Your Lordship, the council would like to answer that question. However, Council 2, who is representing the respondent, the Union of Indica itself, is much well versed with the facts of that particular issue. And therefore, I would like to invite my co-counsel to answer those questions and proceed with her submissions.
You can say.
It was an honor arguing before this bench, and I invite my co-counsel to take up.
Good morning. I am the second speaker representing the respondents today, and I will be arguing on the third issue, stating that the MFN clause of the Indica Emerald DTA cannot come into effect without an express notification being made to confer such a benefit from the side of Indica. Furthermore, it will also be averred that since such a notification has not been made,
We heard the ASIC Council completely.
Indeed, Your Lordship.
They are only asking for a prayer for a notification from the government of India.
Indeed, Your Lordship.
Correct? They are not saying dividend is not taxable under the present law or anything else.
Indeed, Your Lordship.
And nor you are bringing that point.
Indeed.
The point for both is that they ask this bench to direct the government of India to issue a notification.
Indeed, Your Lordship.
So what is a grievance for you? The government should not issue a notification, or we should not entertain that objection is what we want to understand. What is your grievance on this? We are merely asking for a notification now. And if the bench decides, we'll direct the government to issue a notification. And if the government issues a notification and other country, Emirate also accepts it, it becomes a law. What is your objection on that? What is your grievance on that?
The counsel for the respondent humbly submits that following the decision of the Supreme Court in the case of Nestle SA in 2023.
Sorry?
Following the decision of the Honorable Supreme Court in the case of assessing officer versus Nestle SA in 2023.
Nestle was on a complete different facts. Nestle was an issue where the taxpayer claimed the benefit of most favored nation clause. applying a lower rate of dividend. And the Supreme Court held that if you need to get a benefit of MFN clause, the government should issue a fresh notification.
Yes, Your Lordship.
They are not asking for a dividend exemption. They are only requesting. In fact, what they are asking is in line with the Supreme Court judgment. That is, please direct the government of India to issue a notification.
I understand the grievances of the concerns of the bench, Your Lordship, but the council would like to submit that in Nestle SA, it was reasoned that the passing of a notification amending a DTA by enforcing the notification, importing the benefit of the MFN clause, amounts to a power of making of law. It's a power of legislation. It is a word before this bench that the writ of mandamus simply cannot be passed to ask the government to undertake a process of law.
So you are questioning the writ of mandamus.
Indeed, Your Lordship.
Okay.
Additionally to this, since the appellants have also relied on the doctrine of promissory estoppel, the council will be arguing that since the notification has not been passed, there has been no clear promise or assurance made from the side of the Indian government to the SSC. Therefore, the SSC cannot rely on invoking the benefit of promissory estoppel. If the council may proceed on this sub-issue. Just one moment. It is acknowledged that under the protocol to the Indica Emerald DTA, the duty lies on Indica to inform and pass a notification for the application of the MFN clause once triggered. However, in the absence of such a notification having been passed, it cannot be claimed that any benefit has been granted to the SSC or that a vested interest has been created. You see, Your Lordships, the doctrine of promissory estoppel contends that where a party has, by word or conduct, made to another party a clear, unequivocal promise or representation which intended to create legal relations, affect a legal relationship to arise in the future, and such other party acts on such a clear assurance, then such assurance should be binding on the party making it, and the party cannot be allowed to go back on such representation if it would be inequitable to allow them to do so. It is a word here that this doctrine is not attracted due to no clear promise having been made to the SSC by the Indian government. Any DTA is a diplomatic product of extensive negotiations and compromises made between two contracting nations, which lays down the benefits conferred therein carefully, which was a standing that was reflected in the case of Union of India versus Azadi Bachao Andolan, as well as in the Nestle SA case. Hence, any change made to such a treaty, like the importing of another provision, would have to necessarily be subject to renegotiations and compromises, which will look to incorporate such a change while also trying to maintain the essential framework of the agreement. In the absence of such a notification being passed, importing the benefit, there is no way for the SSC to be aware of the final form that the clause would take after such importing is done, after negotiations and policy considerations come into play from the side of the Indian government as well as from the side of the Emerald government. Therefore, they cannot claim that a clear and unequivocal promise, assurance, or representation has been made to the SSC that any final form of benefit will be conferred to them under the clause. In addition to this, it is also submitted that the doctrine of promissory estoppel cannot be invoked in order to spur a legislative exercise.
Council, can you please
Explain this doctrine of promissory estoppel normally is between two contracting parties.
Yes, Your Lordship.
Now, in this case, the DTA is between two contracting states.
Absolutely, Your Lordship.
That is state of Indica and state of Emerald, if I'm not mistaken.
Absolutely, Your
Right.
Lordship.
Now, a subject of state of Emerald is aggrieved because state of Indica is not keeping the promise which it has made to the state of Emerald. And
Yes,
therefore, they are before the court. The government has not acted upon the promises which the representation which has been given out in the DTA agreement.
Yes, Your
So
Lordship.
why would you say the court is not empowered to issue a mandamus to the government to issue a suitable notification in terms of the DTA agreement?
Your Lordship, if the council may refer to the case of Nestle SA again, wherein it was held that passing of a notification which would amend the DTA following the triggering of an MFN clause is an exercise of legislative power. If that conclusion is held up, and referring to the case of the Supreme Court in
Facts are different. The facts are different. I'm reading from the annexure given to this. Moot
yes, Your Lordship,
proposition.
absolutely.
Please read the relevant portion, relevant extract of protocol.
Yes, Your Lordship. It is agreed that if after coming into force of this agreement, any agreement or convention between Indica and any other country provides that Indica shall exempt from tax dividends, interest, royalties, or fees for technical services arising in Indica, or limit the tax charged in Indica on such dividends, interests, royalties, or fees for technical services to a rate lower than that provided for in paragraph 2 of Article 10, or paragraph 2 of Article 11, or paragraph 2 of Article 12 of the agreement, such exemption or lower rate shall be made applicable to the dividends, interests, royalties, or fees for technical services, either generally arising in Indica and beneficially owned by a resident of country emerald, and dividend, interest, royalties, or fees for technical services arising in country emerald and beneficially owned by a resident of Indica under the same conditions as if such exemption or lower rate had been specified in those paragraphs. The competent authority of Indica shall inform the competent authority of country emerald without delay that the conditions for the application of this paragraph have been met and issue a notification to this effect for application of such exemption or lower rate.
So competent authority of Indica shall intimate the competent authority of Emerald.
Yes, Your Lordship.
Correct.
Yes, Your Lordship, indeed.
So you go back to a Supreme Court judgment in Nestle and other one. What the Supreme Court said? Any MF1 clause to be implemented needs a fresh notification.
Indeed, Your Lordship.
That notification needs a discussion, negotiation, alteration of treaty. All those things are accepted. I'm not saying it's not a simple CBDT circular.
Indeed.
This notification needs a discussion between two countries. Competent authority will shall inform. Then both the countries shall discuss it. Then both the countries shall amend the treaty and say that this protocol is amended from this date to this date. Correct?
Indeed, indeed.
Now, that is what Supreme Court judgment said, and that is what the the appellant also seeks the facilitation of the court to issue a writ of mandamus.
Indeed, Your Lordship.
Now, how did you come to a conclusion that this request or this appeal is not in line with the Supreme Court judgment?
Your Lordship, in their prayer, the SSC is not asking for the court to direct the government of Indica to begin the process or to undertake such negotiations or to submit proof that such negotiations or the process has begun. They're specifically asking the court to issue a writ of mandamus, directing the government to issue such a notification. It is being argued that issuing such a notification is an act of legislative
Okay,
power.
I will go one step further.
Yes, sir.
This court directs the government of India to issue a notification.
Yes, Your Lordship.
Being a policy matter, the court will not interfere in the policy matters.
Yes, Your
The
Lordship.
court shall say that the government of India the court directs the government of India to take adequate steps
Yes, Your Lordship.
to issue a notification.
Yes,
When we mean notification, the government of India will take all the necessary steps which is required to be effective,
Yes, Your Lordship.
right?
Yes, Your Lordship.
So then where is the technical objection on that side?
Your Lordship, it is.
Let us forget about mandamus, writ, certiorari, all those things for a minute.
Of course.
Let us take a simple language.
Of course.
They ask for a plea. We are just directing the government, assuming without admitting, we are directing the government to issue a notification. What will be the challenge for you in that side?
Your Lordship, because the notification amending the DTA will be submit to negotiations between two contracting nations, and those negotiations themselves cannot be interfered with by the court, as pointed out by Your Lordship. There is no clear way for us to know whether the benefit will be imported from the Indica Sapphire DTA as it is into the India Emerald DTA, whether the benefit will be changed, or whether the benefit will even be imported after such compromises and negotiations are made. That is what the respondents are contending before this court. Your Lordships have led the counsel through the entirety of her arguments. So if the counsel may be permitted to go on to her conclusion and then the prayer. Much obliged. In conclusion, in the absence of an express notification specifying the manner in which a benefit is supposed to be applied, following the triggering of the MFN clause, it cannot be assumed with finality that the government of Indica has made any clear representation or clear promise to the SSC regarding such a final benefit. In fact, without such notification already having been passed, the SSC could not know for certain the form that the MFN benefit would take after being imported, and therefore cannot rely on the same until the notification is passed. Therefore, until a notification is passed, putting the MFN clause's benefit into effect, the SSE cannot claim that any clear representation or promise has been made to them by the government of Indica, and hence cannot invoke the doctrine of promissory estoppel. If the council may please move on to her prayer.
No, only one before you go to the
Please.
prayer.
Please, Your Lordship.
This MFN clause is part of a protocol or is an independent notification?
It is the MFN clause is a part of the protocol.
What is the function of a protocol in the treaties?
Your Lordship, to the extent of the knowledge of the counsel for the respondent, the protocol adds context and to the original agreement of the DTA.
Okay.
If the counsel may move on to her prayer. Much obliged. Wherefore, in the light of the facts stated, issues raised, arguments advanced and authorities cited, it is most humbly and respectfully prayed before this Honorable Supreme Court of Indica that it may be pleased to before this Honorable Court of Indica, my apologies, that it may be pleased to hold that this Honorable Court dismiss the present petition filed by the SSE, holding that it is devoid of merit. Second, this Honorable Court uphold the order passed by the Honorable ITAT and affirm the final assessment order of the AO. Thirdly, reject the SSE's prayer for the issuance of a writ of mandamus, directing the Government of Indica to issue a notification under Section 90 of the Income Tax Act for granting of the MFN benefit under the protocol to the Indica Emerald DTAA. Fourthly, pass any such order of further relief as this Honorable Court may deem fit and proper and in the interest of justice in the favor of the revenue, and or pass any order as it may deem fit in the interest of justice, equity, and good conscience, all of which is humbly and most respectfully submitted. Such winds up the arguments of the respondents in front of this honorable bench today. It has been a pleasure to argue in front of this bench. Many thanks.
Yes.
The council seeks permission to proceed with the rebuttals on behalf of the petitioner. Your Lordship, when you have the law, you state the law. When you have the facts, you state the facts. And when you have none, you beat around the bush. And that's what the respondents had been doing the entire time.
I'm sorry, can you repeat it again?
When you have the law, you state the law. When you have the facts, you state the facts. And when you have none, you just beat around the bush. And that's what the respondents
Just to give a context, sorry, I'm digressing. It is the words of former Supreme Court Judge K.S. Paripurna.
Indeed, Your Lordship.
He said, if you're sure on the facts, argue on the facts. If you're sure on the law, argue on the law. If you're neither sure nor on the law, argue on the constitutional validity of the provision. That's what Justice Paripurna said once.
Indeed, Your Lordship.
That will be only addressed in the seminars, not in the court orders.
Just for the...
Go ahead.
Your Lordship, firstly, if we come to the time limitation issue,
Yes.
Section 144C was brought in via the Finance Act of 2009. Section 153 of the Income Tax Act has been subject to amendments after that as well. That is how the 2021-22 assessment year, the time limitation has been amended. After that, the time limitation has also been subsequently amended. This helps us to understand that Section 153 has been subject to amendments even after bringing in 144C of the Income Tax Act. Your Lordship, for an assessment to be passed under Section 143 of the Income Tax Act, 153 has to be abided. My learned opposing counsels have stated that they have abided by Section 144 and passed an order under Section 144. But the demand notice is raised under Section 156. Therefore, 143 has to be in consonance with that. Because the order has to be issued in 143 for a notice to be raised under 156 of the Income Tax Act, Your Lordship. Further, the jurisprudence behind 153 and 144C, as the council has established, the internal mechanism of 144C has to be harmoniously interpreted with 153 and
How do you respond to the Department Council on Madras High Court judgment which you brought it here and they said that it's not relevant or it is not correct? So how do you respond to that in only 1 minute?
Indeed, Your Lordship. Your Lordship, the council here is referring to the judgment of the Madras High Court in reference to the jurisprudence laid down by the court with reference to the non-obstant clause present in section 144C, as the council had referred in the compendium as well, that the non-obstant clause on 144C does not override section 153, and that 153 has to be abided by the department. Therefore, Your Lordship, to understand the differentiation and the implementation of section 153 and the essential time limitation, the council had brought to the light of this honorable bench, Your Lordship. Further, Your Lordship, the council would like to state that with regards to the FTS issue, the DIT versus Lufthansa case is with regards to wet leasing of aircrafts. Wet leasing of aircrafts is a very specific provision and a specific act with regards to aircrafts. The aircraft regulations are also different. In our case, UAVs, that is, the unmanned aerial vehicles, are subject to the drone rules. The rules applicable are different in both these regards. The law applicable is different in both these regards because the services and repair wet leasing of aircrafts.
The only fact is that I'm not going to know the leasing of aircraft rules or the drone rules. Neither we are not concerned about it.
Indeed.
The simple point, according to them, is that this is a very specialized equipment and it needs a special skill. Therefore, it cannot be compared to normal repairs. So, how do you say your equipment or the repairs are special repairs or normal repairs? Just give it in 30 seconds.
Indeed, Your Lordship. Your Lordship, my learned opposing counsels have stated that the use of any standard facility and repair using it does not come with an FTS. In our present matter, the OEM facility is a mere standard facility and it has been used for mere support and repair service, which does not fall within the definition of section 917 of the Income Tax Act. Your Lordship, further with regards to permanent establishment, which has been mentioned in the written submission and has been limitedly pleaded in the arguments, the council would like to state that if it is established that there is a permanent establishment, if arguendo assuming, then the entire order of the assessing officer is wrong because it has to be then charged under capital gains as business profits under Articles 7 and 12 of the DTAA, Your Lordship. It would not fall under Article 12, that is under the definition of FTS, Your Lordship. Further, Your Lordship, if we come to the writ issue, which is a substantial question of law, my learned opposing counsels have not addressed the part where they did not respond to the representation because para 13 and 15, which have been subsequently stated, specify, Your Lordship, an extension of 1 minute to conclude with the writ. Your Lordship, it has been specifically stated that representations were filed, and after that, a writ of mandamus was filed before the Honorable Court, which helps us to understand that since no action was taken by the government, the assessee would approach the Honorable Court with regards to this. Further, promissory estoppel in DTAAs and international agreements, if are not abided by, it would hamper international relations, Your Lordship, to a very great extent because two sovereign entities are involved in these transactions, and it is not just the assessee and the department which is involved. Therefore, Your Lordship, the council would like to conclude with the rebuttals on behalf of the petitioners. It was indeed an honor to plead before this bench.
Your Lordship, could the counsel for the respondent just take 1 minute to put together their rebuttals before beginning? Much obliged.
Are you coming now back now? If you want 1 more minute, you take 1 more minute. Also.
No, Your Lordship, we are well prepared. For her rebuttals, the council would first like to submit again that the application of the Roka bathroom products judgment is only with regard to section 153, subsection 3, which deals with an order of fresh assessment rather than an original draft assessment order. Secondly, the council in their oral submissions has not indeed argued on the existence of a permanent establishment, as a finding on the same is not required to tax the SSC as fees for technical services. Lastly, when it comes to promissory estoppel, it has been substantively argued by the council that the doctrine, the basic ingredient of a clear assurance being made for the doctrine of promissory estoppel to be invoked has not been met in the present case. That concludes the rebuttals for the respondents and conclusively concludes the arguments that the respondents will be putting forth in front of this honorable bench. It has been an honor to argue in front of this honorable bench. Thank you.
With that, we come to the end of the rounds. We request all the participants and spectators to remain seated and be silent.
ఇలా వేంటల్లా
A very good evening to one and all present here. I kindly request all of you to put your phones on silent. We've gathered here for the valediction ceremony of the 20th edition of one of India's most prestigious moot court competition and also to celebrate the legacy of one of India's brightest legal luminaries, Shri Nani Palkhivala. To begin with, may I now request all of you to kindly stand up for the invocation song. Shri Bhajata Akhila Jetru Maitri Bhajata Akhila Jetru Maitri Bhajata Akhila Jetru Atmavadeva Pashyata Atmavadeva Pashyata Siddham Jajata Sakala Janana Neyo Bhuyat Sakala Janana Neyo Bhuyat Sakala Janana Neyo Bhuyat Sakala Janana. Thank you. I request all of you to kindly be seated. The 20th Nani Palkhivala Tax Moot Court competition has been a grand success thanks to the unwavering support of our esteemed management of Shastra University. Established in 1984 as Shanmuga College of Engineering and conferred university status in 2001, Shastra is ranked among India's top universities by NIRF and global agencies like Times Higher Education. Accredited by NAAC with an A++ grade, it is also recognized as a Category 1 university under UGC's Graded Autonomy Regulations 2018. The Moot Society at School of Law Shastra is dedicated to shaping competent legal professionals and strengthening the university's presence in the national mooting scene. By hosting the 20th edition of this prestigious competition, we continue our commitment to holistic legal education and practical learning. Now, I invite Kumari Sandhya Uppli, the co-convener of this edition of the Nani Palkhivala Tax Moot Court competition, to deliver the welcome address. Success isn't always about greatness. It's about consistency. Consistent hard work leads to success. A very good evening to one and all present here. On behalf of the Moot Court Society of Shastra Deemed University, it is my absolute honor to welcome all the dignitaries and members present today.
It has been our privilege and pride to have hosted the previous editions of the Nani Moot and to host the 20th edition of Nani Palkhivala Memorial Tax Moot Court Competition and keep Nani Palkhiwala's legacy alive. First and foremost, we extend our sincere greetings and warm welcome to the honorable jury of the final round of the 20th Nani Palkhivala Memorial Tax Moot Court Competition. Honorable Justice Shri C. Saravanan, to whom we express our sincere gratitude for taking time out of his very busy schedule to serve as a member of the jury. We are grateful for the time and effort you've dedicated to being part of this event, and we are sure that your insights will make this competition an unforgettable learning experience for all the participants. Shri P.H. Arvind Pandian, Senior Advocate and former Additional Advocate General of Tamil Nadu, to whom we extend our heartfelt gratitude for his unwavering commitment and invaluable contributions over the years. His knowledge and wisdom have helped shape this competition into the success it is today. Shri K.R. Shekhar, partner at Deloitte India, we express our sincere gratitude for his incredible dedication and insightful contributions as a member of the jury in our moot court competition over the past 2 years. His contributions have elevated the quality of the competition and provided inestimable guidance to all the participants. The 20th edition comes to life, as always, under the benevolent blessings of our Reverend Chancellor, Professor R. Sethuraman, respected Vice Chancellor, Dr. S. Vaidya Subramanian, respected Registrar Shri R. Chandramouli, respected Dean Planning and Development, Dr. S. Swaminathan, and Dean School of Law, Dr. A. Balasubramanian, sir. The 20th edition of the Nani Palkhivala Moot is supported by the C. Nadrajan Chair of Legal Studies under the aegis of Shri N. Venkatraman, the Additional Solicitor General of India, who has always been a guiding light in conducting the previous editions of the Moot. We also extend our sincere greetings to all the participants who have demonstrated remarkable enthusiasm and brilliance. We extend our appreciation to them for having delivered an intense and exciting competition. We extend our greetings to the Tanjavur Bar and Bench for their presence and support. A warm welcome to all the esteemed faculty members present here, as well as to all the print and electronic media who have been an integral part of this competition. To our valued guests and audience, your presence here today adds warmth and significance to this event. With immense pleasure, we welcome you all once again to the valedictory ceremony of the 20th Nani Palkhivala Memorial Tax Moot Court Competition. Thank you.
Thank you, Sandhya. May I now request the Dean School of Law to present the dignitaries on the dais with mementos. May I now request the Dean to felicitate Honorable Justice Shri C. Saravanan, Madras High Court. May I now request the Dean to felicitate Shri P.H. Arvind Pandian, Senior Advocate, Madras High Court. May I now request the Dean to felicitate Shri K.R. Shekhar, Partner, Deloitte. Thank you, sir. We have with us some of the most brightest legal luminaries in the field of taxation law. Honorable Justice Shri C. Saravanan is the sitting judge of the Honorable Madras High Court with a legal career spanning over decades. A graduate of the prestigious National Law School of India University, Bangalore, he completed his BA LLB honors in 1994. Following his enrollment with the Bar Council of Tamil Nadu and Puducherry, he began his practice with notable firms, including the chambers of Senior Advocate Aravind Dattar, specializing in service laws, administrative laws, labor laws, and public interest litigation. His expertise extends to intellectual property rights, excise, customs, service tax, sales tax, and arbitration proceedings. His exemplary legal acumen and dedication led to his elevation to the High Court, where he continues to serve with distinction. May I now request the Honorable Justice Sri Saravanan to deliver the keynote address.
Respected Vice Chancellor, Mr. Vaidya Subramanian, Dean, Mr. Balasubramaniam, Senior Advocate, Mr. Arvind Pandian, my friend, Mr. Shekhar, K.R. Shekhar, Partner Deloitte, Mr. Ramana, Senior Standing Counsel for Income Tax Department, students, faculties, members from the Moot Court Committee. Good evening to one and all. It's indeed a pleasure to be here this evening amidst this gathering. In fact, I was very touched, moved, and inspired when I heard the prayer song, invocation song of this college. Very, very beautiful and enchanting. I'm very happy to be here this evening to give this valedictory address. Some advices which I may give. It's an unsolicited advice to most of you who may be stepping into the profession in few years' time, maybe this year or next year or year thereafter. All of you should remember the gestation period in this profession is very long. So it takes about 5 to 10 years before you actually settle down, and the rewards are immense. The success will follow all of you, whoever works hard. The luck will favor whoever works hard. The money is only a byproduct. It's only your enthusiasm and the industry which will carry you forward. But this 10 years, first 5 to 10 years is very crucial, because you need to dedicate yourself not only to upgrade your knowledge, because once you are out of the college, your exposure will be limited to the area of practice, whichever area you choose, and that's where you will be practicing. So you must cultivate a habit to continue to read widely, write articles, if possible, team up with advocates and authors who are writing books, and eventually author a book on any new topic which comes up, any new law. For instance, now the 3 criminal law and the Evidence Act have come into force. So it's a field where you can actually write something new, compare it with the old laws and compare it with the earlier laws, and can be the author. And courts are looking forward for those kind of literature, especially when we are writing judgments. Similarly, the tax law is very complicated. In fact, as far as I'm concerned, I had very little experience of income tax. I did most of the indirect taxes. Only after my elevation, I got exposed to the income tax. There is so many areas which requires a lot of interpretation, lot of area which has not been examined by the courts. And if you write articles, we as judges, we look forward we do research ourselves. So we Google sometimes, we look into the journals. Sometimes good articles are there. They provide good insight. These are tools which will help you to build a credibility. So as I mentioned, the gestation period is very long. All of you should cultivate a hobby, which you should continue to maintain all through your life, because that will keep you cheerful. Because the profession, you will see, every day is not going to be a bed of roses. It's going to be ups, downs. You will have a lot of challenges, but they are interesting. But you have to go with the motion. Second thing is you must keep a good physical regime. You must continue to have some sporting activity or getting into gym and maintain that regime all through your life, because by the time you're ready to actually taste the success, your health should be in good condition. Otherwise, there is no point in sacrificing first 10 years of dedication without much of salary, without much of reward. When you're ready to fly, you must have the health intact. So continue to have a good regimen as far as physical activities are concerned. That all of you maintain, be it yoga, be it any sports, or even a walk. Don't lead a sedentary life, because especially after COVID-19, most of the, not just the youngsters, I'm saying even the older persons have got used to the digital world. Everything is available on the tap of the finger. So try to get away from the digital world for some time, dedicate some time for yourself, have a me time for yourself always. Finally, I would like to tell all of the youngsters, when you choose an office, when you start working, choose an office very wisely. Try to work in an office on the subject which will help you, or which you are more passionate about. Some of you may be interested in tax law, some of you may be interested in criminal law, some of you may be interested in administrative law. Or if you're getting into teaching profession, it's very interesting because it's very encouraging to interact with young mind and inspire them, because the future is with all the youngsters. It is only in your hands, because you are the people who can actually bring changes to the society. All of you are the architects. Finally, choose a good office. Never get into an office which is known for practicing anything which is unethical. If by mistake you end up joining an office, don't think twice. Come out of that office, get into a good office, and then continue your journey. What has happened has happened. You can't do much about it, but you can improvise upon it, because credibility is very important in this profession. The tongue of word is very important. Nobody should be heard saying that so-and-so worked in so-and-so's office, so-and-so office is not very ethical, so-and-so. So ensure that this particular aspect is maintained by all of you. So ethics, practice your ethics, read philosophies, it will help you. Read books on jurisprudence, again, that will help you. Then when you're coming to court, remember, you have to communicate to the person who's sitting across the bench. You have to communicate in such a way that the message gets across, because you're actually being paid by your client to represent him. It could be the last battle he may be fighting. So you have to put the best foot forward. So communication is very important. So there are different tools of communications, some which are taught in the colleges, and these programs like Moot courts help you. I would suggest all of you to read books on NLP, because you must have heard neuro-linguistic programming. It will help in many ways, especially in courtcraft. A lot of us have learned a little bit of courtcraft watching our seniors, but today the juniors are not sticking on to the seniors for a very long time. It's 3 years, 4 years, they are there and they're setting up their own shop. And because the life has moved very fast, you don't get to learn watching other seniors perform in the court. So those tools will help you if you're able to understand the manner in which a person is disposed of. For instance, a person could be very kinesthetic. So if you're addressing before me, suppose you are able to calibrate me, I'm very kinesthetic, then probably your language should be in such a way that it should be very kinesthetic, so that it really, I'm able to understand what you're trying to convey. Or if somebody is very auditory, so suppose I say, yes, I hear that, I can understand. Or if I say, I see that, it could be a person like me who's very visual. So there are these cues which you may get. But to do that, you must understand what it is, the body language, the nuances, the way in which you give your presentation. Ultimately, the point is one aspect is about the law. The major thing is about the facts. You have to marshal your facts very clearly and then take it forward with the law. Unless you are arguing a case on the aspect of substantial question of law, even there, I would say you have to marshal your facts so that it is very clear for the person who is listening to understand you better. That apart, I would say be cheerful. The world has a lot of promises, so don't get despaired. You can get it. You have the options even to get into the academics. It's very interesting. Many of you can even get into policy making, which is very, very relevant in these days. So world is yours. All of you have a bright future. All the best to all of you. Thank you for putting up with me for this speech. Thank you. Good luck, all of you.
Thank you, sir, for your valuable insights. We'll take your advices and shape our legal careers accordingly. Next, we have with us Shri Aravind Pandian, Senior Advocate, Madras High Court. Shri Aravind Pandian is a highly renowned and accomplished advocate known for his exceptional achievements in the legal profession. He was one of the youngest to be designated as a senior in the Madras High Court. He graduated from Dr. Ambedkar Law Dr. Ambedkar Law College, University of Madras, and has 30+ years of practice in the bar and with core specialization in corporate law, mergers and acquisitions, insolvency and restructuring, and tax law. Mr. Aravind Pandian served as the Additional Advocate General for the Tamil Nadu government for nearly 8 years from March 2012 to May 2021, exemplifies his commitment to public service and his proficiency in handling complex legal matters. May I now invite Shri P.H. Aravind Pandian to grace us with his valuable words.
Honorable Justice C. Saravanan, Mr. K.R. Shekhar, the Vice Chancellor, Mr. Vaidya, Mr. Balasubramaniam, the Dean, my friend Mr. Ramana, all the convener, co-convener, professors, students, teachers, ladies and gentlemen. It gives me immense pleasure once more to stand before you. I should say, I'm part of you or you are part of me in whatever way you can take it. But in a lighter vein, if I may say, always hear the advice of a judge, the arguments of a lawyer, and the theories of I would rather say a professor. So all three combinations were there today to see in what way we not test you, but to see your presentation capacities, your preparation abilities, and finally the tense moments, what you go through when some questions are put across. The finals alone is what we saw, but that itself shows the amount of commitment, caliber, and I should only say the height of intellectual prowess which is going to come into the profession. The feedback has been tremendous to us from almost all our colleagues who are judging the prelims as well as the semi-finals. It is just that two good teams on a good day, quote unquote, for them have made it to the finals. It doesn't mean that the others did not really do well. The performance of this is not to see that when you finish all the moots and you enter the profession, you will be in a position where therefore you're going to be the best lawyer or the having not gone there, you're the worst lawyer. Never. In a lighter vein, he's from a national law school, so he can afford to put a little bit of an air to his cap. We from Madras Law College, as it then used to be called, and then came as Dr. Ambedkar Law College. We used to jump the the compound wall, where only a compound wall separated the High Court and the college. So half the time we'll either be in the courts or we'll be in the college. Now that doesn't say that whether you're in the classroom. So okay, these two alone. Today you can't afford to do that. You have your specific times for internships, you have specific time for your classes, and you also have a specific time for your exams. Now we had only the exams which were sure. Nothing else was sure at that point in time. that helped us to learn a lot during that period, when even if you were in college or out of college, whenever, that the profession is a jungle out there, how well you're prepared. And on a given day, as the judge said very clearly, understanding what the court wants, understanding the view of the court, looking at the judge and finding out what he is looking out for or she is looking out for is the most important part of the case, because a client knows that you are supposed to know the facts, you are supposed to know the law. But how do you, on that given moment, try to not use the word convince, understand the court's mind and put it across? That is 80% of the work. 20% is already done. 20% only is your preparation and the other things. I mean, to tell you, to walk this 30 feet here took me 30 years. So imagine how long it will take for everyone. It doesn't matter that really we are sitting so close, but each one of us have to walk the talk. I've gone through it. The Honorable Judge has gone through it. The profession, and to speak for even just Mr. K.R. Shekhar, it is a different aspect in each profession. A profession doesn't mean that it typically means that one is a better one than the other. What troubles he would have gone through, he knows better. So this profession is something which is absolutely exciting in the last 2 decades of development. The areas of specialization, you want to go to court and specialize? Yes. Without going to court, you have umpteen number of opportunities now available. And the various other, I would rather say, areas of expertise have been explained by the Honorable Judge also. I would like to just wish all of you a wonderful future. Look at the profession not with what you see in the next 20 years. Look at it in a longer perspective, because you have just started. The profession has already started for you in college. It's not when we were there at that point, 30 years back. So that way, do not be too, I would say, kind of a very narrow view that I want to do only this. Because when you say that, you tend to also widen your perspective. Keep it for the first 5 years, in my view. As the Honorable Judge said, 10 years is when a very patient game has to be played. And once you cross the 10 years, you will get another idea also. And lastly, the competition today, in whatever manner for the last 2 days went through, is to not find the best team, but to find how well you are equipped with. With these words, I once again thank the Vice Chancellor, the Dean, and the whole team for having invited me to be part of this competition. Thank you for a patient hearing. Thank you, one and all. Have a wonderful day and a week. Thank you.
Thank you, sir, for your words of wisdom and understanding the current generation. Your words of appreciation really lifted the spirit of the competition. Next, we have with us Shri K.R. Shekhar, currently a partner at Deloitte. Shri K.R. Shekhar is a distinguished professional who began his career in 1985 as an article clerk with T. Selvaraj & Co. After qualifying as a chartered accountant in 1988, he pursued a successful career in taxation, starting with Sanmar Group and later moving to Nagarjuna Group. In 1997, he entered consulting and joined Deloitte in 2002, becoming a partner in 2004. A respected figure in taxation, Shri Shekhar has contributed to the field by representing taxation policies to the Government of India and authoring several books and articles, particularly on DTAA. May I now request Shri K.R. Shekhar to deliver a few words for us.
Before I proceed, let me offer my humble pranams to my living God and Kanchi Shankaracharya, Shankara Vijayendra Saraswati. Without his blessings, I don't think I would have achieved even 1% of what the person talked about me. It's indeed a great moment for me to be personally present. Thanks to my good friend, Mr. Vaita Sastry, Vice Chancellor, who invited me continuously. It's like this. If you scored well in one innings, you are getting opportunity in second innings. So I think I scored well in the last innings. I got an opportunity. Thank you, sir. And I should thank your team for phenomenal hospitality, which I should appreciate the fact. From your office, before I come here, these people fly here. I don't know how they came. And they receive here. From here, they come ahead of us. Thanks to the entire team for the phenomenal hospitality of Shastra. Thank you, guys. Very, very thank you so much for you. And thanks to the two teams presented today. In fact, very honestly, I was sharing with the Justice and Mr. Arvind Pandyan when I was lucky, whether I was not so sure whether I would have prepared even 10% of it. And the subject, what you took is a complicated subject. That sort of issues comes to me day in and day out for my advice. 143, 153 versus 144C, 917 in case of repair of services, ordinary services, special services, comes day in and day out. In fact, in Deloitte and like Deloitte or any organizations, we do a lot of debate. But I could see the lot of clarity of thought, clarity of ideas and clarity of facts. We really appreciate you for what the way you have done it. Don't bother about what scores comes in, that we leave it to the honorable judge to decide how to go about it. But kudos to all the team members, both the team, you did extremely a good job. Let me be very honest. Particularly the issue of MFN clauses. I most questions on MFN clauses to get an answers. Not that I wanted to make answer to you, but just to get an answers from you, how much you prepare. Our objective is not to see whether you read from the text, how much you answer the questions on the feed. That is what an important job of a council. Both the teams did very well on that. Kudos to you. Keep it up, this good work. That's all I would like to say that. And one few advice to you, tips to you. I will not call advice because advice is very easy in this world. But I'll give few tips to you people, every one of you. Don't stop the learning after you graduate. Learning continues. If you have to be in the field of knowledge, whether it is taxation, transfer of property, intellectual property, the learning continues. And even today, whenever any client asks for a brief, I will not go to case laws first. I will not find out which case law is in my favor, which case law is against me. I should read the facts thorough and go to the sections which impact the facts. And income tax is one subject that gives the complete all-round view of all the legislations. For example, a most favored nation clause, you should go to UN Treaty Negotiation Manual, which tells how MFN clause has to be read. And the matters relating to international tax, whether it is tax, whether it is intellectual property rights, whether it is transfer of property. Today, world has become one village or one place. So there are a lot of international precedents it is applicable to you. For example, you talked about a most favored nation clause. There's a fantastic House of Law judgments on most favored nation clause in respect of trade and intellectual property rights. What is the function of an MFN clause? How it controls? So you should read a lot, continue to read a lot. That's my first advice to you. Never ever stop. Just because we get some money after some point of time, don't ignore the learning. If you ignore the learning, money will not come after a point of time. The reason is that, I don't know how, I have the lot of Ramana or Mr. Arvind Pandyan would recall it. Solely the student at the age of 90, if you go for a briefing, he will not take the case law first. Let's say, Shekhar, what is the fact? Let me take section 9.1. That section 9.1 you would have written at least 1 lakh times because you would have represented all the cases on section 9.1. He still reads section 9.1 like as if he read the Income Tax Act yesterday. So reading is important. Never ignore the base sections. That's very important. And I have the privilege of interviewing some candidates for Deloitte, and they being a big four, they said, I would like to do an international tax first. Don't jump to international tax at the beginning. You have to master the charging section of 9, section 5, section 6, section 10, all those charging sections you have to master. Then you go to DTA. Don't jump into DTA at the beginning. It is a fascinating world. I'm not denying it, but without becoming an expert on the domestic tax law, don't try to go to DTA. You will get fault. That's more important. The other important one is I can share my two experience from before the tribunal, because being a chartered accountant, I cannot appear before the honorable judge like Saravanan or anybody. I can only appear before the tribunal. Mr. Justice Ishwar was listening to my argument. It's a famous case, it got reported, called ICDS Limited, where it's a secondment, whether it's a permanent establishment, whether it's a reimbursement or secondment, it's a fees for technical services. Though I know Justice Ishwar when he was arguing from 1980s, I know him, but in the bench you can't exhibit all, you have to argue. The argument started at 10:30, it ended at 2:30. 5 hours, he quizzed me every line of my argument. Fortunately, I got a favorable order. The reason is that when you are arguing, when you're particular litigation, whether it is income tax, whether it is a company law, whether it is any law, the judges keep asking questions not because they are not aware of it. They ask questions to know whether your answers is what important for them to conclude it. So prepare answers, don't just restrict your preparation only to the facts what you are there. Get your preparation across. For example, when in the discussion I asked 194C and 194J distinction, you should get off the feed there. So these are the few tips. The more important, I will emphasize much more. Credibility and value is what is more important in professional life. Particularly the people who appear before the judges and the High Court. I'll just give a practical experience. One of the Madras High Court judge retired. I don't want to name the judge. I don't want to name the counsel. The judge passed an order. In my view, that order is incorrect. In fact, in Tax Sutra, they asked me to analyze top 100 rulings. They said one of these rulings. Knowing, I know the judge personally very well, I said this one of the ruling I would not like to analyze because this ruling tells how not to interpret a treaty law. Other judgments tells me how to interpret a treaty law. This judgment says how not to interpret a treaty law. I asked the judge, why did you give this sort of a judgment? The judge answer is only one, Shekhar, I'm not able to believe the appellant counsel who argued before me because his credibility is very low. I was not so sure about the facts, what he's told me. Only one line. Everything is else, but I'm not able to believe the judge. So the point is that the credibility what you get in the courts, in the tribunals is what important, what influences the judge. I'll give a classic second example. I can name the counsel here. I was briefing Mr. Harish Salve way back in 1988 on an excise matter. And he was asked us to come on Friday evening. Monday was the matter in Supreme Court. So Friday evening we were there. Those days no mobile and all. So Friday evening we were there to brief Mr. Harish Salve. He was not there. He was got stuck in Mumbai on some other matter. He came on Saturday. He was proposed to come on Saturday. Saturday he did not come. Sunday he did not come. Monday morning he came. At 8:30 he asked us to come and brief him finally. It was a matter of excess, a classification. Fortunately, in our preparation, we posted 2 photographs of the product, what we manufacture, what the product that would come under central excess classification. We posted 2 photographs. At 8:30, we went to brief him. He was very busy because a very senior lawyer. He was very busy. We were not so sure whether he heard us or not. The matter came in Supreme Court. So we thought that let us pray to the God whether we win the matter or not. He went to the Supreme Court. The judge asked, what is the issue? He said, Your Honor, this is the product I manufacture. Department wanted to classify this product like this. You decide what is correct. 2 minutes over, I got a favorable order. Now here is a court craft and his ability to take things. So if you are in a litigation, that's very, very important. And his credibility also is very, very important. So my request is that enhance the credibility. Don't compromise on the value. And last but not that least, if you believe the person who is employing you has followed some unethical practices and he has got some question marks on credibility, don't take the cases. That's all my advice to you. And thanks once again for all the participants. And thank you so much, Mr. Vaita sir and Shastra for inviting me. And thank you so much. I really enjoyed it. In fact, with your permission, I'm going to take this case law and brief to my juniors in my office, asking them to look at it. Thank you so much. Thanks a lot.
Thank you, sir, for your words of appreciation and offering insightful career guidance. As part of celebrating the legacy of Sri Nani Palkhivala, the Sastra School of Law conducted the Nani Palkhivala Memorial Elocution Contest on 30th January 2025. The competition saw participation from various law schools with a distinguished panel of judges evaluating their performances. After fierce competition, top 3 participants have been awarded the prizes. May I now request the Dean School of Law to give away the prizes to the winners of the elocution competition. The winner of the contest is Kumari R. Shalini of 3rd year BA LLB Honours from Tamil Nadu National Law University, Trichy. On behalf of our Shalini, we have a participant from TNNLU to receive the same. The second prize goes to Kumari Aparna Tiwari, 3rd year BBA LLB from Shastra Deemed University. The third prize goes to Kumari Varsha S, 2nd year BBA LLB, Shastra Deemed University. They are awarded with a cash prize of rupees 5,000, rupees 3,000 and rupees 2,000 respectively. Thank you, sir. As we approach the conclusion of the 20th Nani Palkhivala Tax Moot Court competition, we take pride in the incredible journey that has unfolded. This edition saw the participation of teams from across the country, including some of India's most prestigious law schools. The competition was conducted in multiple phases with a pre-quarter and quarter-final rounds held online last week. After intense debates and rigorous arguments, 4 teams advanced to semi-finals, culminating in a grand and competitive finale. The most anticipated moment has arrived. I now invite a distinguished judges to present the awards. The individual awards will be presented first, followed by the winner and runner-up trophies. Firstly, it's the award of Best Researcher. May I request Shri K.R. Shekhar to present the Best Researcher Award. The Best Researcher Award goes to Mehul Sharavanan from Tamil Nadu National Law University, Trichy. Let us all give him a huge round of applause. Thank you, sir. Thank you, sir. May I now invite Shri Aravind Pandian to present the Best Speaker Award and the Best Memorial Award. The Best Speaker Award goes to Adya Nair from National University of Advanced Legal Studies, Cochin. May we all give her a huge round of applause? The Best Memorial Award goes to Team TC02, National Law University, Delhi. Due to logistical reasons, they are not available here today with us for the valedictory ceremony. Thank you, sir. Now, for the highly anticipated moment, I request Honorable Justice Shri C. Saravanan to declare the winners and runners-up of the competition.
Congratulations to all the winners. We had a tough time giving marks to both the teams. It's easier to deliver a judgment than to select a team which deserves the prize. In our assessment, both the teams were very good and they matched and outmatched each other's. In our assessment, each of us came to a unanimous conclusion that both the teams are winners. So may I request both the teams to come? Okay. But we have, yes. Yes, both the teams are winners. Joint winners. Both the teams are getting separate trophies. Both the teams will get the same cash prize. That is the decision also taken by the management.
The winners of the competition are TC12, SSC, Symbiosis Law School, Noida. And the winners of the competition are TC11, Revenue, Tamil Nadu National Law University. Thank you, sir. It was a rather unexpected twist of the evening. A best surprise as well. Congratulations to all the winners. Thank you, sir. As we conclude this remarkable evening, we extend our heartfelt gratitude to all the dignitaries, participants, judges, and organizers who contributed to making this competition a grand success. Your dedication and enthusiasm have been truly inspiring. I now invite Chiranjeevi Himavant, convener of the 20th Nani Palkhivala Memorial Tax Moot Court Competition, to deliver the vote of thanks.
A very warm good evening to one and all present here. It is my privilege to deliver the vote of thanks on behalf of the Moot Court Society of Shastra deemed to be university. I would like to extend my deepest gratitude to the jury of the final rounds of the 20th Nani Palkhivala Memorial Tax Moot Court Competition 2025. Honorable Justice Sri Saravanan, Madras High Court, for taking time out of his busy schedule and for his invaluable expertise. Shri P.S. Arvind Pandian Sir, Senior Advocate and former Additional Advocate General of Tamil Nadu, for his continued support that has aided in the success of several editions of this competition, and Shri K.R. Shekhar Sir, Partner, Deloitte, for gracing this occasion for 2 consecutive years and for bringing unparalleled exercise and insights to this competition. It is indeed a blessing and honor to have you all here, sir. I would also like to express our heartfelt gratitude to the management of Shastra deemed to be university, revered Chancellor, respected Vice Chancellor, respected Dean Planning and Development, respected Registrar, and respected Dean School of Law. I would also like to extend our gratitude to Lakshmi Kumaran and Sridharan attorneys, the knowledge partner of this moot court competition, and the framers of the moot proposition. Further, I would like to extend my thanks to the Nani Palkhivala Trust for having confidence in allowing us to conduct this prestigious moot court competition. I would also like to thank Shri C. Natarajan Chair for Legal Studies, endowed by Shri N. Venkatraman, Learned Additional Solicitor General of India, Supreme Court, and Senior Advocate for supporting this moot court competition. A special thanks to the auditorium staff, Civil Maintenance Department, Electrical Maintenance, IT support, print and electronic media, and the entire Shastra family, without whose support the success of this event wouldn't have been possible. I would also like to thank all the participants of the 20th Nani Palkhivala Memorial Tax Moot Court Competition, whose enthusiasm has made this competition engaging and inspiring. Last but not the least, on a personal note, we are extremely grateful for the tremendous support by our faculty coordinators. I would like to thank various teams of the organizing committee, members, and friends for their involvement and participation in conducting this moot court competition. Thank you all for attending the event, and we hope to keep the spirit of Nani Palkhivala ji alive by conducting more events and contributing to the legal field.
Thank you, Himavant. May I now kindly request all of you to stand up for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल भंगा विंध्य हिमाचल यमुना गंगा उच्चल जलति तरंगा तव शुभ नामे जाहे तव शुभ आशीष माहे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
I request all to please stand as the dignitaries exit the auditorium.